Uninove is one of the top private universities in Latin America and the best private university in Brazil. Uninove's facts really impress. There are 10 campuses in the state of São Paulo and more than 100 distance education centers across Brazil, all equipped with the most innovative technology and infrastructure, built and founded on more than 60 years of history. Originated in 1956 from a typing school and now became a reference for higher education in Brazil. We were awarded with the highest higher education, ranking Times Higher Education, as the best Brazilian private university in social impact. But for us at Uninove, the great prize for social impact is being able to insert over 200,000 students in the job market. It is also to develop partnerships with the most important companies in Brazil. It is also to foster education by offering full scholarships from early childhood education and to facilitate the entry of higher school students who cannot afford and wish to start a university degree. We also offer totally free English and computer science workshops. It is also to grant scholarships for the training of researchers and to be able to offer back to society all this knowledge. Our clinics also serve over 1 million people for free in health and family programs. We promote dental care, medical, psychological, and develop social programs that give full scholarships involving students in important social causes. It is also training and transforming people through education. Uninove, tradition and innovation in transformation through education.
Compartilhamos da certeza de que métodos adequados de resolução de disputas criam ambientes de negócio muito mais dinâmicos. Acreditamos em pontos de vista que, equilibrados, geram soluções mais justas e eficazes. Estamos entre as líderes no Brasil. Há 25 anos, trabalhamos para oferecer serviços ágeis e eficientes com custos de transação competitivos. Câmara de Conciliação, Mediação e Arbitragem Ciesp-Fiesp. Equilíbrio e celeridade.
Fala pessoal, tudo bem? Se você está vindo aqui pela primeira vez, meu nome é Franco Mazieiro.
Oi Franco, obrigado pela pergunta. Olha, o especialista em direito aqui é você, não eu.
E esse é o canal Mais Direito. Não perca todo dia aqui no canal. Às 13 horas, programa Sexta com Direito. A gente vai conversar, a gente vai dar sequência para mais um O que é Arras, TAC, divórcio, desconsideração da personalidade jurídica, Lei Geral de Proteção de Dados, da inteligência artificial, startup, blockchain, guarda, recuperação judicial, técnicas de negociação. Você está acompanhando aí essa sequência de sugestões de temas de TCC, de monografia. Ontem nós conversamos sobre direito de família, direito e tecnologia. E hoje nós vamos conversar sobre direito penal, direito tributário, direito trabalhista, direito empresarial, direito constitucional. Eu queria uma aula com o nosso professor João Bosco do que é direito de concorrência, teoria do jogo e a arbitragem, direito societário, direito previdenciário, as cotas, a indivisibilidade das cotas, hacker, reorganização, arbitration, que é a teoria da imprevisão. Qual que é a diferença entre taxa e imposto, entre DPO e encarregado, entre conciliação e mediação. Vamos dar sequência aqui à correção de mais uma questão. Esse projeto que eu estou me referindo é o projeto Carreiras Jurídicas, que é a de delegado da Polícia Civil. Cartório de protestos do Procurador de Estado, profissão de perito. Muito obrigado a todos vocês aí de casa, sejam bem-vindos ao canal Mais Direito. Já fica o convite para se inscrever no canal para você poder acompanhar todos os próximos vídeos. Um abraço, good luck.
Good morning, everyone. Good morning to all of you in Brazil. Good afternoon to you in Europe. Maybe good night to some of you in Southeast Asia or wherever you are. Welcome to the International Congress in Law and Technology. This morning, we'll start the entire day dedicated to arbitration and its consequences. We'll try to let you know and understand what's going on and what's to expect in the world of arbitration. We have a distinguished panel of guests from India, Bahrain, and Brazil. We have lectures with UNCITRAL model law jurisdictions. We have lectures from people in which the domestic law doesn't differentiate international from domestic arbitration. We will have a very, very interesting panel. With that said, I pass on the word to Badri. Thank you very much for joining us. And please remember, we have 20 minutes for each presentation.
Thank you, Claudio. I am Badrinath Srinivasan. I work as the Senior Manager, Legal in the Directorate General of Hydrocarbons of the Government of India. I work basically as an in-house counsel there. I write a bit about arbitration and contract law, mainly in a blog called as Practical Academic Law. So today, what we'll be doing is, in this panel, we'll be analyzing predominantly two issues arising out of technology. First, we'll be dealing with what is the role of technology in international arbitration and the challenges that parties are facing, especially in international arbitration. And I've taken the liberty of digressing a little bit from the topic by addressing the issues of technological innovation, startups, and international arbitration. I'll once again link this up to technological solutions in international arbitration. Now, we notice that there is a symbiotic relationship between international arbitration and the role of technology. And we all know that international arbitration, like all of us, has been severely affected by the COVID-19 and the consequent lockdown and the quarantine. So we've all adjusted to this new normal, as people are fond of saying. And thankfully, there is some light at the end of the tunnel. Russia has recently announced that it has found a vaccine. Let's hope everything goes on for the best and see that the entire world comes out of this. But just to think about it, what would have happened had COVID-19 struck about a decade back? Would international arbitration have come to a standstill? Because those were the days when internet speeds were not that great. And it would have been a real challenge. And I guess had international arbitration not stopped, most of the proceedings would have shifted to exchange of documents, exchange of written submissions, and less of oral submissions. But thankfully, in the current world, because of the excellent surge in technology, we have the entire arbitration ecosystem shifting to the virtual world. But fundamentally, some problems are there. Many practitioners have been complaining that eye contact with the tribunal and the concept of this witness demeanor are lacking in a virtual world. But whatever it may be, let's hope things go for the best. But in this short topic, I'll be addressing two fundamental challenges to international arbitration in a virtual world. The first is the internet infrastructure. If you look globally, not everything is monolithic. Different countries with different cultures, different traditions are there. Likewise, there is a kind of relativism in respect of internet speeds also. If you notice that on the one hand, or on the one side of the spectrum, there are countries like Singapore, US, and jurisdiction like Taiwan, which have got extraordinarily good internet speeds. While I'm talking about internet speeds, I'm talking about the average internet speeds. In some places in these jurisdictions, the speed is likely to be more or even less. But more or less, the average speed in Taiwan you see in this screen is 85.02 Mbps. Whereas on the other side of the spectrum, you have countries like Nigeria or Yemen with very less speed. I guess countries like Brazil, India are somewhere in between. But all said and done, when, say, a party from, take Nigeria, for example, is arbitrating, and on the other hand, a party from Singapore is sitting, and the tribunal is located, say, in Europe, it is bound that the varying internet connections, varying internet speeds will present a huge problem. And you have natural calamities or even storms brewing somewhere in the world, thereby hindering the smooth development or smooth progress of an international arbitration. And there are also problems of health. Ordinarily, what does happen in international arbitrations is hearings take place for 4 5 days, sometimes even 10 days, 20 days. In fact, in March, we had a hearing scheduled for about 40 days continuously with weekends in between. And all of those had to be cancelled or postponed because of the COVID. But if you shift the same thing to the virtual world, it will be extraordinarily difficult to have, say, 8-hour, 10-hour hearings with people sitting in front of the screen or multiple screens and all. And there'll be this electronic fatigue. So I think the international arbitration community should probably look at scheduling proceedings with 3-hour or 4-hour schedules. And that will present a different problems altogether, but somewhere health and fatigue are also something that need to be taken care of. And another possibility is having interrogatories instead of detailed cross-examination. That will save a lot of screen time. Another very important aspect is differing time zones. Take this panel, for example. One of them is situated in Bahrain, one of few of them in Brazil, and I am situated in India. So we have different time zones operating here. But what if somebody's sitting in Australia or Singapore, for that matter, where the time will be totally different? So scheduling is extraordinarily important. Take the case of a hypothetical scenario where one of the parties is unfortunately bound to sit at odd hours, where the tribunal as well as the other party sits for the arbitration during the day. And let's assume that it's an 8-hour hearing. So one of the party has to suffer that odd hours, and it really becomes difficult for the proceedings if one of the parties is forced to work in odd hours. And there are also chances later on of that party challenging the arbitral process itself. So it is extraordinarily important for the tribunals to schedule hearings in such a way that parties equally suffer odd hours, if at all that is necessary. That concludes my topic as regards challenges, technological challenges and international arbitration. Now, what I'll do is I'll address the topic of how international arbitration becomes a challenge to technological innovation, especially startups. So we all know that startups are, at least in the past 3 or 4 decades, have been great disruptors of technology, and they have been engines of innovation. But the problem with startups is that not anymore are startups considered to be operating in their own jurisdictions. And globalization is now regarded as a matter of survival for startups and not as a matter of luxury or mere expansion of business. Given that it is normal these days for startups to enter into international transactions. And that brings into the element of international arbitration. But how attuned is international arbitration towards the needs of the startups is the larger question that we all need to address, at least from the arbitration community. There are several challenges that international arbitration poses to technological innovation and startups. I will highlight some of those challenges. Of these challenges, some have technological solutions and others have certain other solutions that could also be discussed if sufficient time. Now, what are those challenges? The fundamental problem with international arbitration, not only for startups, technological startups, but for everyone, is that international arbitration is extraordinarily costly. In fact, it is regarded as one of the worst features of international arbitration. And are there reliable mechanisms in international arbitration for smaller parties? So that is one fundamental question that the community, the international arbitration community. Another problem is the adverse publicity of international arbitration. Although we say that confidentiality is one of the hallmarks of international arbitration, yet because of filings with the securities boards or things like that, that there is huge adverse publicity for startups going into international arbitration. Although for larger companies that is a problem, for startups it is a major issue. And while negotiating international arbitration clauses, startups will always on the other side of the bargaining table, in the sense that they hardly have any legroom for bargaining. So this implies that they are forced to agree to certain inconvenient international arbitration clauses. And another fundamental problem is startups do not have that legal expertise to negotiate arbitration clauses or to react to an arbitration invocation or even a stagnation or an interim order. And lastly, there is this impact on case preparation. I think some statistics say that 50% of the startups eventually die in their first 5 years. And most of this problem, most of this causes are got to do with the disputes between founders or attrition of key personnel. So these are the fundamental problems that startups face. Now, given that in the last few decades, there has been strides in international arbitration with respect to diversity. Somewhere post 1990s, there were a lot of discussion on diversities of tribunals, that they should belong to different races or not just one or few races. And since 2005, 2010, there has been a lot of discussion in a positive way about participation of women in international arbitration. I guess it's now time for talks on how well small, medium scale enterprises and startups can be integrated into the mainstream international arbitration discourse. And there is also an urgent need and an important need to integrate the needs of startups with international arbitration. There have been some developments in especially in the COVID-19 world. Like, for example, CIRB has, the Chartered Institute of Arbitrators, has entered into a deal with the CEDR and has come up with a pandemic dispute resolution service. So these are some positive developments, but more needs to be done so that international arbitration does not pull down startups from their march towards greater technological innovation and disruption. Thank you.
Claudio, you're muted. I think you need to unmute yourself.
You see, problems of technology. That was easily taken over. Thank you very much, Badri, for your speech. Let's move on and have João lecturing about the actual performance of arbitration services in Brazil.
Thank you so much, Claudio. It's such a pleasure to be here discussing arbitration technology, well, in exceptional times, in times of a sanitary crisis. It's so good to be here with Badri, Mariki, sharing with all of you some thoughts and some views in these topics that became very big, very fast in the arbitration and dispute resolution community worldwide. So I'm João Lessa. I am the Secretary General of the Chamber of Conciliation, Mediation and Arbitration, CIESP. I'm a lawyer here in Brazil. So the thoughts I will present, they reflect the view of how things are being done in the Brazilian scenario regarding both domestic and international arbitration, but also how courts have reacted to the pandemic and the social isolation. So basically, it's a situation where we look to the impossibility of presential hearings, of presential filing of documents, and things need to move to the virtual arena, to an online option for things to continue functioning. But the first thing we need to bear in mind is that the interaction of technology and dispute resolution is not in itself something new, quite the contrary. Technology do impact dispute resolution in many ways for a very long time, really. First, when we think about the way that electronic analysis of documents has affected the volume of data we can cope with, and that has been around for some time. That's quite impressive. The possibility of distant contact with people abroad easily, this has been around for some time as well. But what we are looking in this specific moment we are going through is the necessity of virtual hearing, because people cannot move around, they cannot travel, they cannot gather in the same rooms, and also the necessity of paperless e-filing of documents for the same reason. So bearing that in mind, that those interactions of technology and dispute resolution, they always happen, but we are in an exceptional scenario. Whenever we face something new, something as shocking and severe as the pandemic crisis, it's normal that when we look to these situations and how they affect the way we work, the way we do things, we will go through some phases. And the very first thing we have is doubts. We don't know how things will develop, how things will go, what is the new normal. New normal is an expression that's quite been used in Brazil to describe whatever is coming. So we are in doubt of whatever is coming. But then we start to have experiences in this new scenario. We start to face whatever is out there, and some things we may like, some things we may dislike, some things we may want to, reverse and go back to how things used to be before as fast as we can. And some other things we may want to keep because they're good and they actually mean some improvement to the way things used to be done. What I'm trying to say here is that in these three phases, from exceptional moments of crisis, doubts, new experience, and then new perceptions, we are always learning something. And I think this is something to bear in mind on the interaction of technology and ADR in this moment. We are learning from a unique circumstance, from a unique moment, and some things we may approve, some things we may like. They may actually mean an improvement to the way arbitration domestically and internationally used to be done, and others may be challenges and things that we actually see that before we had a better experience and provided better services to those using arbitration. But in this point, I want to go and look to some theory of what we do, or just to recall that arbitration as a private jurisdiction, it's all about the notion of due process. So it doesn't matter if we are looking into a paper-based case or an electronic case. What we need to aim, what arbitrators, arbitration institutions, the lawyers, what they need to provide and need to find in arbitration, it's due process of law, because this is the fundamental right of the parties involved in the proceeding. And of course, this is a very broad notion that encompass several different perceptions. So the right to be heard, the right to produce evidence, the right to question the evidence produced by the other party, maybe challenging the admissibility, maybe producing evidence in another sense, the right to take part in every single step of the proceeding, the notion of parity among the parties, of not being in an unfair position or in a disprivileged position because of lack of access to technology, for example, but also this notion also relates to the whole possibility of being present and having an influence in the outcome of the arbitration. So the parties, they need to have the chance to make their case, to present their case, and to influence the arbitrator's conviction and the outcome of the war. So arbitration is all about fair participation. And when we look into technology, and I think that Brady explanations brought some possible issues regarding internet connection and other things that are related. But to have good arbitration, we need to guarantee the whole notion of due process of law, because this is a fundamental right, or in a more international approach, is a human right relating to procedure. But of course, issues regarding to fair participation in proceedings, they arise not only in an international scenarios. So we have some new issues, and we still have the old issues of before in the arena. But bear in mind that the arbitrators, the arbitration institutions, what they are requested, what they have to do when providing dispute resolution services is to try to even the gaps between the parties, is try to create, even in exceptional circumstances, the possibility for everyone to be heard in a fair way. And with that in mind, I would like to look a bit to the experience of the Chamber CIESP, with virtual hearings, specifically in this exceptional moment we are going through. The Chamber CIESP, of course, is also sponsoring and supporting this event. But just to give you a general figure of what I'm talking about, it's a chamber with over 25 years of activities in Brazil. It's one of the oldest arbitration institutions in the countries. Is also one of the most in demand, with over 650 cases in the past 25 years. So, and there we were working when in mid-March, things in Brazil just came to a lockdown. Basically, no gatherings were allowed. Those are still very restricted in the country, with some regional differences depending on the city or the state. But basically, the thing impacted the dispute resolution community in Brazil was basically that, look, people cannot go out to file documents. People cannot go to hearings. People cannot gather together. They have to stay in lockdown at their homes. So basically, two options were presented there. We could either suspend the services and say, look, during the pandemic, all time limits are suspended by decision of the institution. But this would have, of course, a very bad impact on length of proceedings and on the parties that they want to have their disputes solved. Or we could provide for alternatives. So basically, the presidency of the chamber edited two resolutions regulating e-filings of documents, sending documents basically on PDF format, reproducing the physical documents, and also implementing virtual hearings. We put our whole staff, our whole secretariat team on home office, so people working from home. Of course, we took precautions to guarantee internet access, connection for the team, and also virus protection. So we did set up how things would work for our team. And then the case is the first impact we heard from users of arbitrations, both Brazilian users and foreign users, was a bit of waiting. In the first few weeks, first couple of weeks, people were waiting because they didn't know how long the pandemic would take. And now we are in mid-August and it's still ongoing in this country, still ongoing in Brazil. So over 5 months now. But in the first couple of weeks, people were waiting. So we had a few hearings postponed. We had many questions from the parties, the lawyers, the arbitrators on how things would work in this new specific and exceptional time. But truth is, as the thing progressed, and also because it became clear that the pandemic would not go away quickly or easily as one might have hoped when it all began, the cases continued to proceed, including to having virtual hearings. And in this time, since April to 2020, we had 19 hearings in the chamber. The chamber do provide for a virtual connection and infrastructure, also provide guidance and information for the parties in the arbitrations. We test every single connection in advance, so our staff will get in touch and make sure that your internet connection is good enough. We'll also give general guidance on how to use the platform, and also some etiquette notes on how to behave, on what to do, do's and don'ts in the hearing itself. But we got some impressive numbers, 19 hearings, so they all came back. And those hearings, they involve disputes worth 1.2 billion Brazilian reais, roughly $220 million. So quite big figures. In this time, we also got new cases, and those cases, they were filed paperlessly. So cases that were filed only electronically, with 25 new arbitration cases since April, worth about $500 million Brazilian reais, just over $100 million in new disputes. So what I'm trying to say and to bring with this figure is that the dispute resolution market did not stop in Brazil, quite the contrary. So things kept happening. But we also had, we currently have 99 ongoing arbitration proceedings. And out of these cases, we had 11 cases that the parties or the arbitrators chose to suspend either the hearing, postponing them, and clearly indicating that they want to have in-person hearings. And others, they were just suspended in general, including filing of documents, because that was what the parties and the arbitrators chose to do. So roughly 11% of cases impacted in the sense that they are not moving forward to a conclusion because of the pandemic. And that's absolutely fine in our view as an institution. What I'm trying to say is that it's really up to the parties and the arbitrators to understand which are the needs of the case. If it's appropriate or not to have a virtual hearing, if the infrastructure, of the parties, of the witnesses, of the expert witnesses, everybody that needs to be connected, if their connection is good enough, or if we're gonna have issues, this all have to be weighted in the light of an exceptional circumstance. In the end of the day, there is always a trade-off on going online. We might get something new. People don't need to travel, so they might be saving on costs regarding to plane tickets, hotel bills, meals, etc. So this may have some impact in the proceeding itself. But also there are other issues regarding connection, regarding people who are unwilling to cooperate. But people who are unwilling to cooperate, they tend to do the same presentially. So let's not forget that with in-person hearings, all kind of issues also could arise, just because it's a very important date to everybody involved, and people are not always willing to cooperate as they should. But it's really down to the specific needs of the case, of what the parties want and what the arbitrators deem fit to know if a case should be suspended, if a virtual hearing is appropriate, or if the option is to wait when things resume to normality. And I hope this will be very soon, because it's a very sad and difficult moment we are all going through. But as an arbitration institution, our duty and our aim is to provide alternatives, is to provide the best tools possible for the cases to continue. And insofar, our experience has been very, very positive in the chamber CSPS. In these 19 hearings since April, we had no major connection issue. We didn't have any major question really regarding their functioning. we had quite large hearings. We had hearings with over 60 people. And of course, this demand more attention and more work from our staff and support team. But in general, things are going really smoothly. But again, when we look to that, we have to bear in mind that maybe, at least for the Brazilian lawyers and parties, maybe the community, the dispute resolution community is more used to technology. Court proceedings in Brazil, they have been electronically in all levels, state courts, federal courts, and the superior courts. They have been electronical for quite a few years now. And also presentation of cases before the Brazilian judiciary, they also are being done electronically through video conferences now. So it's something that to the lawyer is not, at least to the Brazilian lawyer, is not something that's new to go to an arbitration hearing that's going to be online or virtual, just because it's the same that his firm is doing in the judiciary in general. So things for us in our experience have been quite good in the sense that we learned a lot on how to do things virtually, and in this time of crisis, we did need to adapt to keep providing good services in an appropriate standard. So some may ask if I'm taking too of an optimistic view regarding virtual hearings on arbitration. Actually, not. I'm just sharing our impression, what we saw in those cases, and what I'm hearing. I'm discussing with people from Brazil and abroad. I know that Marike has had some rough experience, and she will maybe bring another light to the question. But in general, our experience it's good. And again, we cannot compare pears and apples. Virtual hearings, they are not the same as in-person hearings. They are different. You may have some advantages, and you may have some disadvantages. What we need to bear in mind is that we need to work with both, that everybody who is involved in the arbitration process need to cooperate, and especially the arbitration tribunal and the institutions, they need to provide the framework and guidance for the parties and lawyers, always aiming to guarantee the right of a fair proceeding, of a fair hearing, and the whole sense of due process. But again, these notions, doing that is not providing exactly the same as things were done before in presential hearings. And when I look to the future, I think that some features, they may stay, because those are good experience. I think that in the future of arbitration, we'll have more and more sort of mixed hearings. Some people getting together when that's possible due to sanitary conditions, and a few people coming into virtual connections to take part in the hearing. Maybe a witness, maybe a lawyer from another country, maybe someone who is involved in the proceeding may not need to go to the place where the actual hearing is happening, because they can go online, and those tools, they have been tested. And to some cases, the parties and the arbitrations, they may even think that it's better to do all virtually just because it's simpler, or not, or they want everything to be presential. What I'm trying to say is that after the pandemic, the new normal, if you like, is the possibility for parties, lawyers, arbitrators to choose this mix of presential and virtual hearing, presenting documents physically if they think this is appropriate, or filing them only electronically if this is more convenient to them. So I think we have, in the sense of flexibility, and flexibility is always very important to good arbitration, we have a good chance to learn and try to do things better in the future. So Claudio, those were my thoughts on the topic, just sharing a really broad view. And I hope to take part in the debates later on. Thank you.
Thank you very much, João. You see, we have to learn from mistakes in technology. I just turned down my microphone before it starts speaking, so I learned. Uh, and thank you very much for your either factual review or optimistic view. It's very good to know that things are actually working in Brazil. Brazil is a very pro-arbitration jurisdiction. João just posed us the views and the experiences of one of the top three institutions in Latin America. Thank you very much. We now move on to Mariki. Mariki, we have had the opportunity to discuss the implications of technologies. So I myself thought we were in the very middle of the pandemic and its consequences, but that was about 3 or 4 months ago. So turns out it was at the very beginning of the pandemic, in which we have absolutely no idea where will it end, if we'll ever come. I mean, we will come to have a vaccine, but we don't know the consequences for the future. I tend to agree with João that this new normal is becoming the actual normal, but we have to learn from mistakes. I mean, we have to adapt the technology. In my experience, be it in hearings, virtual hearings, and even in teaching classes. I mean, the technology is evolving. We still have a lot of problems, but do you think we're nearing the solution to some of those problems, or are we just beginning? I just want you to address this very question in the middle of your presentation. Thank you very much for joining us once again. It's a real pleasure to have you joining us at this event.
Thank you, Claudio. Now, you and I both come from a culture of soccer, and I heard João say there are advantages and disadvantages. So let me just quote Johan Cruyff, who is probably the most famous soccer player of all times in the world, who said every advantage has a disadvantage. So you asked us to share with the audience who we are and where we're from, where we're trained. That's a very confusing question for me when people ask us, as airports give us your passports and nationalities, we come with 8. And so let me just try to summarize it in a way that I understand. I am based in Bahrain, but I'm a Dutch national with an Indian heritage, trained in the Netherlands as a civil lawyer, but then making the journey across the pond to the United States, where I learned about this phenomenon called the common law. I work with a US-based Washington firm led by former Secretary of State Madeleine Albright, so that is not law, that is politics. So when you ask me, what is my connection? I guess that might be some global virtual world. There are nuances, and there like João says, there are disadvantages, advantages. We have to make the best of it. I fully recognize this. I fully recognize that we're in a pandemic, and we are all under different types of lockdowns, and we have to make the best of it. But this is a debate. This is a conference, and for the sake of a debate, I am going to leave all the nuances at the door, and I'm going to play the devil's advocate, the pessimist, the person who feels that the glass is not even half empty, it is empty. We've reached the bottom. Like Claudio said, we did a webinar some months ago. I still felt this, this lockdown might have its advantages. We can do things that we normally cannot do. Now, at the end of the summer, I think a lot of working mothers are ready to check into a spa with, therapists. So we're done. We are done. So that's that. Now, let's go a little bit into the world of music, since that makes us happy. So I want to talk about Prince. Everybody knows him, and he wrote this song 1999. I think the movies of Back to the Future were also from around that time. And change is good, but I wish we were back in the 90s. Now, in 1999, let's go back to international arbitration. Gerald Hermann, a very, very known, well-known international arbitrator, former president of the International Council for Commercial Arbitration, the leading institution on international arbitration in the world. Great sense of humor, even though he was German. I'm Dutch. He made a great prediction if you will, at a Freshfields lecture. When I wrote my book on the New York Convention in 2016, I talked about awards and what awards can be enforced under the New York Convention, the treaty that enforces awards across the globe. And then I said this in my book. This is my point one. I've got 10 points to share with you today. What about an award that had emerged from an entirely virtual environment? An arbitration agreement that provides for hearings via video conferences, submissions, briefs via emails. And then I quoted Gerald Hermann, who said in 1999, while a-national or free-floating awards are more common in the imaginative world of radical delocalizers than in the real world, we may wish to anticipate future space awards rendered in cyberspace, virtual cybitration by the Galactic Arbitration Center. And if only Gerald would have known that in 2020, the world is thrown into a lockdown and we are having virtual arbitrations. We've been jumping off that high dive. We've been thrown off the high dive and it wasn't a choice. Like my friends say today, could we have postponed all the hearings? Can we postpone arbitrations? No, we have to go on. And I agree with Zhao. He's leading an institution, arbitral institutions. The saying is the show must go on. You have to try to accommodate the parties. You have to try to continue. You have to try to host these arbitrations. And Zhao, I think your center has done a marvelous job, is doing a marvelous job. But let me get to point 2 of my 10 points. And you've already talked about it, Badrine and Zhao, due process. I look at due process from the enforcement stage because the enforcement is something I love. The parties might be happy now. The parties might say, gosh, we continued our arbitration. We didn't have to wait until after the lockdown. Nobody knows when that is. But things are happening. The proof is in the pudding. But are we having the cake and eating it too? I don't know. When it's about international arbitration, involving parties everywhere in the globe, lawyers in different countries, arbitrators in yet different countries, like Badrine said, the internet connections are not the same everywhere. Internet connections are not created equal. We haven't really done this before, although we were having e-discovery, blockchain arbitration, trying to do some virtual hearings. We were sort of slowly at our lawyer pace, trying it out. Now we just have to do it full on. And we see things, there is a storm. Internet doesn't work anymore. One arbitrator has an internet connection issue. You cannot hear one of the lawyers. So there are technology glitches. What if, because of that, the hearing needs to be extended? So we need to add 3 more days, but one of the arbitrators already has something else scheduled. Okay, sorry, we cannot do it. What if a witness is being cross-examined, internet shuts down, and we say, okay, we'll start after the weekend. The witnesses have to be sequestered for 2 days. There's so many what ifs, but those ifs are happening. And you can say, well, the parties are agreeing to it, but rest assured that when it comes to enforcement, the losing party is going to have a field day like it's 1999 with Article 5.1b of the New York Convention. Point 3, Badrine and Zhao have mentioned it. Everybody's talking about it. Interpersonal, nonverbal communication. I can see all the speakers, the participants can see us, but can we really see each other? Can we really see what's going on? Can we see the little hints? One thing, and I'm happy that Claudio forgot to push the mute button, when you have a debate, or you are cross-examining, or you want to object as a lawyer, or the arbitrator wants to ask a question, every time you have to push that mute button. You cannot really raise your hand. It becomes harder to have something that's more interactive. Those who are terrified of technology, I'm one of them, will say, never mind. I'm just going to do the absolute minimum and we'll just see how it is. Due process violations will follow. Do the parties really get what they are entitled to? Point 4, soft bench. What does this mean? What is a hot bench? My former mentor, Albert-Jan Vandenberg, who has been listed for a long time as the leading arbitrator in the world in international arbitration, talks about a hot bench. These are the arbitrators who have reviewed all the documents imaginable. They know it, they are prepared, and they are asking questions. They are in that hearing from beginning to end. They are there. Now, Badrin talked about diversity. I created Young ECA. We have been fighting for regional diversity for a decade. I'm a woman, needless to say. We think about gender diversity, but I'm also Dutch, so I can be the one who takes the elephant out of the room. Most arbitrators in the current arbitrator pool are of a certain generation. They are not like my son, 9 years old, who just handles an iPad like he was born with it. They are those who are terrified that something is going to happen to their computer as we speak. Those arbitrators who are now sitting as arbitrators in virtual cases, who have 2 computers, screens, the transcript, the witnesses, seeing the other arbitrators, are thinking, I'm not going to touch anything. I just want to get through this. I want to get through this. And at the end of the day, they think, whew, nothing happened today. See, now something is happening to my screen while I'm speaking. So I'm hoping you can still see me because I lost some sight. Yes, do a thumbs up. Okay, thank God. See, ooh, this is like nerve-wracking. Anyway, so these arbitrators are more focused on not having a technology disaster than that they're in the moment in the hearing. So you are getting a soft bench instead of a hot bench. Point 5, enforcement. I'm just getting back to that. That's my mantra. The lawyers for the losing party can do 2 things. They can resist the enforcement on the basis of Article 5.1b of the New York Convention. Due process is going to be a new Pandora's box, or public policy. There are some countries in the world, especially in my region, the MENA region, where countries will say, we don't do Zoom, we don't allow it. This means that many of those parties, maybe their lawyers in London can do the case, but they cannot be present. Is that a policy matter? Could judges of those countries say, we cannot enforce this? I'm thinking out loud. This has never happened before. Point 6, cost. So one thing that I just love is everybody saying, oh, you don't have to travel anymore. No more hotel costs. Now, how much do IT, like Badrin talks about startups, tech firms, those are startup firms. Tech firms are having a field day. They are not going bankrupt right now in the sense that they need to assist all of us to manage and navigate this new virtual world. So now with big international arbitration hearings, sometimes you need 3 technology firms. They need to prepare the arbitrators, the institution, the parties, the lawyers, the witnesses, the translators, the expert witnesses in advance of the hearing. During the hearing, they need to be there. How many hours is that? What is the cost? Is that more expensive or less expensive than the cost of a plane ticket? Point 7. And I'm obviously the pessimist. So now I'm saying, well, maybe after the pandemic, virtual hearings are here to stay. What does this sound like? This sounds like third-party funding is here to stay. We might as well accept it. Then we need to regulate. How do we do that? What are the rules? Who's going to decide on the rules? So for example, some arbitrators are now saying, I want to see everybody on the screen, even if you're not speaking, even if you're not being cross-examined. I need to see everybody. Who decides? What happens during the breaks? Where are you supposed to be? For witnesses who need to be sequestered, should we have a camera in their office so we can see what they're doing? Is this big brother is watching you? What are the rules of due process for virtual hearings? Just like with e-discovery is different. So do we need to regulate? Maybe, but how are we going to regulate? Point 8, Pandora's box. Just like Jao said, even if you have in-person hearings, trust the lawyers to be, what should I say, devious. Trust the lawyers to develop guerrilla tactics. Trust the lawyers to develop a toolbox to abuse the process. Well, what do we think? Are they going to abuse this? I do think so. I think that lawyers will see, okay, there was a due process violation here, there's a due process violation there, there was a Zoom problem here, there was a technology issue here. When my client loses, I am going to open that Pandora's box. I'm going to get my little devious tools out and use it. So we need to be careful. Parties need to know. That is also part of this point. I think that if there is a choice after the pandemic, that parties need to be informed by lawyers what this really means, how this arbitration hearing is going to be different, what the risks are. We need to have some sense of ethics that we do that. Point 9, I'm almost there. So we're talking about hearings. We can see each other, right? I can still see you. My computer hasn't crashed. Some arbitrators are saying, I want to see everybody. Why? We can hear each other. I mean, we're not sitting in the same room anyway. Why? So at one point we might say, well, maybe just audio. So then my question is, why do we have hearings at all? Maybe just this written phase. So this becomes a question of, let's revisit arbitration, the process of arbitration from the get-go. And then point 10, and this is an odd one, but I'm going to do it anyway. Humanity. What do I mean? So this is not just arbitration. This is teleworking. This is the United Nations doing sessions through webinars. This is homeschooling. This is the whole pandemic turning the world into a virtual reality because we have no choice. I just mentioned my 9-year-old who loves iPads. I'm not from that generation. I love the 80s and the 90s. But everybody knows, just think back of before the pandemic. Think back of that time, that normal that seems so far away, that you take the metro, you're outside on a square, you're waiting in the doctor's room. What do you remember of that? What you remember is that everybody is on their phone. Everybody, instead of seeing the person next to you, you're sending a WhatsApp message to somebody else. Brazil loves WhatsApp. We have a new world of social media. We're already no longer connected with each other. And behind the safety of our screens, and all of us, there could be thousands of people watching us right now. But as far as we are concerned, we're sitting at home with our cup of tea behind the screens, not aware how many people can actually see us. That's the same with social media. That's the same with sending people emails. It's so much easier to do it through that virtual route. I have learned a long time ago, pick up the phone or walk into somebody's office. Don't send them a message, when can we meet? Walk over and say, when can we meet? Look at the person who's sitting next to you. We've already lost that before the pandemic, and now we're being pushed over the edge. And that's a part of this virtual reality that I find dangerous. Bringing that back to the arbitration hearing, normally at a hearing, when you present, it's your formal self. You are presenting an oral argument. As an arbitrator, you are listening. You are being formal. But it's during those breaks that you get to know the personalities. You've just lost that. And with that, I want to end with my little devil's advocate speech. I exaggerated a little bit. You have to sympathize with me. I'm a working mom who's been at home for 6 months trying to manage it all. So I'm almost over that edge. So forgive me for my negativity, but I feel it had to be shared today. Thank you.
You see, just open my microphone. Thank you very much, Mariki. That was very enlightening. We now should start and engage into discussions amongst ourselves. We do have questions, but prior to that, I just want to pose a couple of questions to you guys. Badri, I think the operative word here is learn. I mean, learn from mistakes, learn from experience, learn from practice. Do you think in the world of startups, the institutions are learning something? And I don't mean exactly the quarantine and the lockups. It was very clear to me that there's a long way to go. What do you think they're missing? I mean, is there a gap to fill?
In respect of international arbitration and technology?
Yes.
Okay. So I'm really glad that I started first. And number two, I was not very much neither in favor of virtual hearings nor against it. I was like a cat on the fence. I'm feeling sorry for Jao because he has a lot to answer to. But then, yeah, I'm from India. I'm from Asia. So just to say a few things about gaps that Claudio is talking about. When I go to an international arbitration, I feel scared sometimes. I feel out of the place. You know what I mean? It's a white world, so to say. To be very honest, the arbitrators are English or European or Anglo-American, and the lawyers are Anglo-American, and some of us feel out of the place. that is the same with technology also. Some of us are so much uncomfortable with technology. So therefore, take whoever or whatever, everybody will have some problems against them. But then the question is whether, so what is the alternative? Do we have any choice? Oh, number two. Now, virtual hearings. Why do we do virtual hearings? Why do jurisdictions say, I'm sure English courts and so do Indian courts also, they say, to the extent possible, you continue with the hearings, right? Why do they do that? It's not just a matter of the proceedings going on or to show to the world that these jurisdictions are advanced jurisdictions. It's a question of money. At the end of the day, no money comes just like that. It comes because of hard work of the employees, of the lawyers, right? So people have to earn. And if there is a debt that needs to be paid, somebody has to go to the courts or to the tribunals and get it enforced, right? So therefore, it's a question of necessity. It's a question of survival that international arbitration has to run, virtual or otherwise. So that is my point. Now, the thing is that today we are looking at the difficulties that we are facing with international arbitration in the virtual world. Tomorrow there'll be a scenario where, just like Star Wars or Star Trek, you'll have holographic images in a particular room, and parties kind of holding arbitrations through holographic images, where many of the problems might get eliminated. But at the end of the day, the show has to go on.
Indeed. Thank you very much, Badri. João, the question we have here is, it seems that the institution is indeed ahead of its time. And I myself was using the structure of CSP, FIESP even before the pandemic, and we had a few online arbitrations. The question is, has the institution learned too much? Because you said that you have not had any problems. Do you think you're already adapted, or, as Mariki just pointed out, dark times are about to come?
Well, I don't know if we are ahead of time or not. I'm just basically sharing the facts. And to be fair, we got loads and loads of questions from lawyers, arbitrators, especially in this new moment. Of course, there were a few virtual hearings before, mainly hearings regarding concerning reunions on terms of reference and maybe simple conferences of tribunal, just because it was easier to do that way. So we did have some experience before, but you know, when this is a necessity, people will then start to have questions. And what we did is try to create a framework. So the Secretariat of the Chamber created a set of, if you like, soft law rules, guidance, really, a guidebook on virtual hearings, and explaining them how our platform works, things they need to be aware before, during, and after the audience, all kinds of things. Well, making sure they are in a private and secure connection, that they do not use public Wi-Fis. You need to tell people not to use public Wi-Fis when going into arbitration, for example. Telling people that they need to have a camera that will allow that will be possible to rotate around the room if the arbitrator so requests, just to make sure that they are alone in their room. We need to tell people that they have to be alone in their room if they are a witness, because people are at home, and we got mothers at home and they have children coming in. So what we try to do is really explain to them and tell, look, this is a formal moment. You need to bear in mind that this is one of those moments that you would leave your home and go to an office and stay there for a whole afternoon. So behave in the same way, dress in the same way. And I'm talking about dressing because people, they are at home, so someone might show in pajamas. We're seeing all kinds of things in the internet, and don't think that those cannot happen in arbitration. So what an arbitration institution can do is, choose a good and trustworthy platform, for virtual hearings, test them, guide people on how to use this platform, give general guidance to party, these lawyers, arbitrators on how to use this tool and how to behave in the environment, and do all the best. But of course, even as an institution, there is some lose of control over the hearing. What I want to say is that in an in-person hearing, and we have a very good hearing center here in São Paulo, we are in our hearing center, our offices, our people, you know, even if you want to record the hearing, that's possible, but it's our people, you know, operating the cameras, recording, taking the notes. It's our staff all around. Of course, we still provide for that, but we cannot control the connection of the witness. We cannot define the notebook model or iPhone model of the arbitrator who is coming online. We simply cannot do that. So we still retain control of many important issues on the hearing, but of course we need to collaborate with people involved in the hearing. So Claudio, in the end of the day, it's all about trying to explain, provide guidance, really take time. And when I say every single hearing, our case managers will call everyone, will get in touch with everyone and test the connection in advance and open the platform and tell them how to do. I mean, this takes time. Don't think this is easy to do. It's much easier just to tell them, come at 9 o'clock on Monday for our hearing, and that's the address. Just show up here and it will work. Though there's a lot of work to make the virtual hearing function appropriately, but this has to be done. And again, I brought the numbers, and out of 99 cases, 100 cases we have ongoing, 11 were suspended or at least had virtual hearings postponed indefinitely. So those are cases that are waiting to see how things will go because they think that an in-person hearing, it's important. And again, to us, this is absolutely fine. I mean, in the end of the day, our commitment, our concern is to provide good services in either formats. The only thing is like it's like a baby bird leaving the nest. At some point, we just have to jump, leave the branch and fly or not. But I mean, not flying is not an option when you are providing. I mean, this arbitration community is a very sophisticated community, so the standards are very high, and people are asking all the time, and they want to know how things are done. So again, Claudio, it's really $1 million question, but just to summarize, it's a sum of factors, several things. But again, we did get apprehensive when things started. But even as an institution, when you are apprehensive because you got a new scenario, your role is to calm down parties, arbitrators, and show options, opportunities, and then leave to them to decide whatever is best. Arbitration institutions, they need to be very discreet in what they do. And even when they're supporting, they need not to be the center of attention. This is down to the arbitrators and the parties. So those are the ones really conducting the cases. We try to provide tools at the end of the day.
Thank you very much. I have a question to Mariki as well, but it's very, very funny that we're going to ask you this question, Mariki. I just want to show you the setting for my side of this question. We know that as arbitrators, we have a duty to render an enforceable award. And I've heard in so many tribunals that we can only do what we can only do. I mean, we have nearly 200 jurisdictions that we could go for enforcement under the New York Convention is 160 some. But we have too many jurisdictions, and it's really impossible to learn everything. And on the other hand, we have the tools. I mean, we have the technology, and artificial intelligence is evolving so rapidly. And prior to asking this question, we have a chat for this seminar, and one of the kids, they just said, "Oh, we're talking about Mariki," and she said Back to the Future. And we just got a recommendation from Netflix to see the movie Back to the Future. So technology is evolving and we're learning a lot. And we have at some point to rely on those tools. And well, that comes to my question that says, we have a question to Mariki. What measures can the arbitrators adopt throughout the procedure to avoid allegations of due process violation at the enforcement stage? Should blockchain arbitration take care of that? Can you enlighten us? Not us, I mean them.
So blockchain, I'm not objective because as Claudio knows, Claudio is also a friend of the University of Miami School of Law. And some years ago with some of my students, we launched blockchain arbitration. And although it was created in Miami, we launched it in Brazil. And the name of that company is actually Samba. And we really promoted it to all the institutions, how fantastic it is. And it's all online, it's virtual, it's secure, you cannot lose it, it's good for the New York Convention. So I think it was one of our first webinars, Claudio, during this lockdown that I said, and also at a conference in Houston online, I said, well, how about blockchain? Because it's more secure, it's maybe a better fit for international arbitration. And then one person said, no, because most of the platforms at institutions don't have the adequate technology to support it. And second, engineers in Sao Paulo have explained to us that blockchain is actually very expensive. So like João said, we need to fly. You cannot stay in the nest. And I love that he said that, because I think maybe even for 2 decades, the arbitration community has been exploring technology. We start with e-discovery, et cetera, but we've been not taking off. We've been like sort of walking, trying to take off, but we're not taking off. And now we had to because of the lockdown. But with blockchain, I think there's still some research that needs to be done. So that's blockchain. Artificial intelligence, I think that's also part of the conference this week. Can artificial intelligence take over, replace arbitrators? You can guess my answer. I think not. But then again, we cannot predict the future. In 1999, when Gerald said cybitration, well, we're in cybitration right now. This is 2020, we're there. In 1999, where those movies were made, we're in cybitration in 2020. So I don't want to say artificial intelligence can never take over, and then 10, 15 years from now, I'm being proven wrong. Now with the New York Convention, 163 states, what can arbitrators do? Because like I said, due process, public policy, it's all going to be used under Article 5. So when resisting the enforcement of the award. What arbitrators are already doing, and they did it in physical hearings as well, is at the end of the hearing, they will ask, are there any questions? Was this to the satisfaction of the parties? The parties will say, yes, we are very happy. And with that, one could argue they have just waived their due process rights. Doesn't really work like that. But one thing that arbitrators need to do, since we're all being thrown off that, pushed off that high dive, is to ask and ask and ask during this whole hearing. Maybe explain, we are doing a virtual hearing, the parties agree to it, we have no choice right now, we're all in the situation together. The chair can say we're going to do this to the best of our abilities, we've all agreed to it, i.e. waiver, but keep on asking throughout the hearing, are there any issues? Does anybody have a technology issue? If there is a technology interruption by one of the arbitrators or the parties and you have to pause for 2 days, point that out. There is nothing we can do about this and this moment. We are trying to do the best we can do to get this back on the rails. So you have to be flexible. You have to accommodate. You have to maybe recognize the weaknesses of a virtual hearing. And then what I would say to judges being presented with an enforcement request and hearing an objection under Article 5, so a lawyer that says, well, there was a due process violation because of the technology aspect. There's one thing that we need to remember about Article 5, is that it has to be interpreted on the basis of good faith. This follows from the Vienna Convention on the Law of Treaties, but also the drafting history of the New York Convention itself, that those refusal grounds have to be construed narrowly, can only be used in serious cases, and have to be applied in good faith. And listening to Zhao, listening to Badin, we are all trying to do this the best we can. That's what Zhao says. We have to go on. The show has to go on. We're trying our best. And so I think that good faith element might save awards.
Thank you very much. We have another question. I mean, we're all talking about we have to regulate, we have to determine what's to be done or not to be done. And the question is, who should do that? Are the institutions in charge of it? Is the lawmakers in charge of it? Are the parties to take care of it? And what would be the role of the arbitrators? I myself think the arbitrators have a very, very particular and special role because we've been granted powers by the law, we've been granted powers by the institutional rules, and we've been given power and a mandate from the parties themselves. So the question to you all, I mean, I just exposed my preference in absence of law or institutional rules. As João said, most institutions, they have enacted rules, not only guidelines, I mean, a number of guidelines, but binding rules on the ongoing procedures. But the question we have here is, you guys, I mean, who you think should be in charge of implementing those needed changes in the procedure? I mean, this is for you all, I mean, not particularly addressed to any of you. And I mean, if I could add, we have a second question addressed to each speaker. So anyone feeling the need to speak, please take the word. We have a second question that some say that the pandemic could have a good impact on arbitration costs simply by having all virtual procedure. But I was thinking if the situation would actually lead to quite the opposite scenario. As a speaker said, parties are going to need the assistance of tech companies. Arbitral institutions are going to have to invest, to heavily invest in technology in order to keep up and advance. Although I highly expect that we could use this situation to make arbitration more accessible in a worldwide scale, and I'm not sure this is going to be possible. So we have those two questions on who's to rule and how to take care of the costs.
So, well, let me go first. And this is the problem with the online. So now we have to sort of do something so that who's going to go first. Anyway, so Claudio, I think it has to be the I'm now being hijacked. This is hello, proof is in the pudding, and it's happening right now. Anyway, it has to be the institutions. Again, like Zhao, his institution is already doing it. All institutions, national institutions, have the right to do it. They should do it. But then the question is, you would have to have some global institution organization that's almost like the umbrella that can provide some general guidelines. So then I'm thinking International Bar Association, IBA, has developed a lot of amazing guidelines for international arbitration that are used. It's then up to the parties based on party autonomy to say, I'm sorry, this is a blooper reel right now, that parties based on party autonomy can say, we are agreeing that those, let's say, IBA rules are going to apply. And then the other thing I'm thinking about, but again, this is a really good question, we're thinking out loud, is UNCITRAL, like it's monitoring the New York Convention, like it has done the UNCITRAL model law, the UNCITRAL model rules, recommendations for electronic communication with the New York Convention, I would say that would be the designated body to develop rules that can be used by everybody.
Well,
yeah, please, João, Badri, do you have something to pitch in, your 50 cents?
no, actually, I would agree with Marike. Of course, the institutions, they have a role to play because they need to regulate their own functioning regarding virtual hearings and e-filing of documents. So they need to do that just because they need to make clear and tell parties and arbitrators how they will proceed in their own part in the in the arbitration proceedings. So they do have a part. But arbitrators, they actually, Claudio, and I do agree with you, they have a very important role as well. Even by procedural orders, setting how things will be done or requesting some things of the parties. So they should take an active role on that, helping proceedings. But I think that in general, as things are being more and more tested, we will move to a set of commonly accepted and shared ground rules, things that they, you know, sort of a state of the art in the market, how things should be done virtually. And as we get more and more experience, things that go right, things that go wrong, we start to understand exactly with what we are dealing with. And then we'll get more rules. Actually, CIARB has some notes on virtual hearings that they recently published in an international level. And I think those are all helpful and good. But again, in the Brazilian perspective, at least, we always need to bear in mind for domestic cases, maybe a bit less to international cases, but in domestic cases that we have quite a few rules of the National Council of Justice regulating how virtual hearings are done for court proceedings. And those can be guidance. Of course, they are not automatically applicable to arbitration. That's not how things work. But again, if lawyers, they are used to this way, and this is helpful somehow, this can be a guideline that can be used. But again, in the end of the day, it's really down to the institutions and the arbitrators in a specific case.
Yeah,
I tend to agree. Badri, we have 3-4 minutes before we have to wrap up. Do you have something to pitch in?
but pardon me for that. But I think that insofar as the engines of innovation and technology is concerned, I think that, as Marike said, prominent international organizations like, say, Untitled or IBA needs to take the lead, possibly arbitral institutions next. But the thing is, like, as far as the evolution of international arbitration in this past half a century is concerned, everybody's done their part, be it prominent institutions, prominent arbitral institutions, parties, numerous countries sitting together in Untitled and thrashing out so many things, and then getting the beautiful instrument of Untitled arbitration rules or the model law in place, and adopting that model law into their jurisdictions. And so jurisdictions, the countries have played a great role. So have parties, so have arbitral institutions, so have parties, so have tribunals. So all of us, everybody has a role to play in insofar as developing the future of international arbitration. And as far as the second question that Claudio posed, as to whether virtual proceedings will lead to cost efficacy in international arbitration, and you had two views here. One, if you're going to invest a lot on technological infrastructure, then the advantage of cost gets eroded possibly. But in the long run, I think that technology is going to play a huge role in controlling costs. Just off the cuff, to think of it, that 5,000 pounds or $10,000 that you're going to spend on transcription services, for instance, gets saved by adopting a video recording of the proceedings if the parties cannot afford transcription. I'm just giving an example. Sorry to the transcription companies if I'm making you unmarketable, but the technological solutions can be adopted in different scenarios.
I also tend to agree. I mean, it seems to me that most of those costs in technology improvements will become sunk costs in the future. They will be incorporated into the toolkit available for the arbitrators. But I tend to agree with Mariki because those costs, I mean, travel, meals, hotels, are somewhat irrelevant in the big picture of international arbitration. I think, just like Mariki said, and we've had these experiences when you have to sequester not only witnesses, even the experts or the arbitrators themselves, those will add immense costs to the arbitration procedure, and we have a long way to go. But I mean, I think it became clear from what we discussed today. And once again, thank you all. I mean, it's been a wonderful panel. I'm getting a number of praises in the chat room. We have thousands of people listening to us as we speak. It's been great, and the lessons will be learning the operative word, just like I said. For all of you listening to us, and of course for the lecturers as well, the 2 p.m. panel this afternoon, we will be discussing the actual implications of information technology and artificial intelligence in arbitration. I hope we all can be available this afternoon and try to learn from our friends. Thank you very much, Mariki. Thank you very much, João. Thank you very much, Badri. And thank you, Uninovi. Thank you, Franco, for putting up this wonderful Congress. And thank you, Fiesp, in the name of João. Thank you very much for making it all possible for us. I mean, for me, it's been very enlightening. And for the all audience, thank you very much. And with that, we will be leaving the room. Thank you very much.
Thank you.
Thank you. Thank you.
Thank you so much.
Uninove is one of the top private universities in Latin America and the best private university in Brazil. Uninove's facts really impress. There are 10 campuses in the state of São Paulo and more than 100 distance education centers across Brazil, all equipped with the most innovative technology and infrastructure, built and founded on more than 60 years of history. Originated in 1956 from a Taipan school, and now became a reference for higher education in Brazil. We were awarded with the highest higher education, ranking Times Higher Education, as the best Brazilian private university in social impact. But for us at Uninove, the great prize for social impact is being able to insert over 200,000 students in the job market. It is also to develop partnerships with the most important companies in Brazil. It is also to foster education by offering full scholarships from early childhood education and to facilitate the entry of higher school students who cannot afford and wish to start a university degree. We also offer totally free English and computer science workshops. It is also to grant scholarships for the training of researchers and to be able to offer back to society all this knowledge. Our clinics also serve over 1 million people for free in health and family programs. We promote dental care, medical, psychological, and develop social programs that give full scholarships involving students in important social causes. It is also training and transforming people through education. Uninove, tradition and innovation in transformation through education.
Compartilhamos da certeza de que métodos adequados de resolução de disputas criam ambientes de negócio muito mais dinâmicos. Acreditamos em pontos de vista que, equilibrados, geram soluções mais justas e eficazes. Estamos entre as líderes no Brasil. Há 25 anos, trabalhamos para oferecer serviços ágeis e eficientes com custos de transação competitivos. Câmara de Conciliação, Mediação e Arbitragem Ciesp-Fiesp. Equilíbrio e celeridade.
Fala pessoal, tudo bem? Se você está vendo aqui pela primeira vez, meu nome é Franco Mazieiro.
Oi, Franco, obrigado pela pergunta. Olha, o especialista em direito aqui é você, não eu.
E esse é o canal Mais Direito. Não perca todo dia aqui no canal. Às 13 horas, programa Sexta com Direito. A gente vai conversar, a gente vai dar sequência para mais um O que é? Arras, TAC, divórcio, desconsideração da personalidade jurídica, Lei Geral de Proteção de Dados, da inteligência artificial, startup, blockchain, guarda, recuperação judicial, técnicas de negociação. Você está acompanhando aí essa sequência de sugestões de temas de TCC, de monografia. Ontem nós conversamos sobre direito de família, direito e tecnologia. E hoje nós vamos conversar sobre direito penal, direito tributário, direito trabalhista, direito empresarial, direito constitucional. Eu queria uma aula com o nosso professor João Bosco do que é direito de concorrência, teoria do jogo e a arbitragem, direito societário, direito previdenciário, as cotas, a indivisibilidade das cotas, hacker, reorganização, arbitration, que é a teoria da imprevisão. Qual que é a diferença entre taxa e imposto, entre DPO e encarregado, entre conciliação e mediação? Vamos dar sequência aqui à correção de mais uma questão. Esse projeto que eu estou me referindo é o projeto Carreiras Jurídicas, que é a de delegado da Polícia Civil. Cartório de protestos do Procurador de Estado, profissão de perito. Muito obrigado a todos vocês aí de casa, sejam bem-vindos ao canal Mais Direito. Já fica o convite para se inscrever no canal para você poder acompanhar todos os próximos vídeos. Um abraço e até o próximo vídeo.
Uninove is one of the top private universities in Latin America and the best private university in Brazil. Uninove's facts really impress. There are 10 campuses in the state of São Paulo and more than 100 distance education centers across Brazil, all equipped with the most innovative technology and infrastructure, built and founded on more than 60 years of history. Originated in 1956 from a typing school, and now became a reference for higher education in Brazil. We were awarded with the highest higher education, ranking Times Higher Education, as the best Brazilian private university in social impact. But for us at Uninove, the great prize for social impact is being able to insert over 200,000 students in the job market. It is also to develop partnerships with the most important companies in Brazil. It is also to foster education by offering full scholarships from early childhood education and to facilitate the entry of higher school students who cannot afford and wish to start a university degree. We also offer totally free English and computer science workshops. It is also to grant scholarships for the training of researchers and to be able to offer back to society all this knowledge. Our clinics also serve over 1 million people for free in health and family programs. We promote dental care, medical, psychological, and develop social programs that give full scholarships involving students in important social causes. It is also training and transforming people through education. Uninove, tradition and innovation in transformation through education.
Compartilhamos da certeza de que métodos adequados de resolução de disputas criam ambientes de negócio muito mais dinâmicos. Acreditamos em pontos de vista que, equilibrados, geram soluções mais justas e eficazes. Estamos entre as líderes no Brasil. Há 25 anos, trabalhamos para oferecer serviços ágeis e eficientes com custos de transação competitivos. Câmara de Conciliação, Mediação e Arbitragem Ciesp-Fiesp. Equilíbrio e celeridade.
Fala pessoal, tudo bem? Se você está vendo aqui pela primeira vez, meu nome é Franco Mazieiro.
Oi, Franco, obrigado pela pergunta. Olha, o especialista em direito aqui é você, não eu.
E esse é o canal Mais Direito. Não perca todo dia aqui no canal. Às 13 horas, programa Sexta com Direito. A gente vai conversar, a gente vai dar sequência para mais um O que é? Arras, TAC, divórcio, desconsideração da personalidade jurídica, Lei Geral de Proteção de Dados para Inteligência Artificial, startup, blockchain, guarda, recuperação judicial, técnicas de negociação. Você está acompanhando aí essa sequência de sugestões de temas de TCC, de monografia. Ontem nós conversamos sobre direito de família, direito e tecnologia. E hoje nós vamos conversar sobre direito penal, direito tributário, direito trabalhista, direito empresarial, direito constitucional. Eu queria uma aula com o nosso professor João Bosco do que é direito de concorrência, teoria do jogo e a arbitragem, direito societário, direito previdenciário, as cotas, a indivisibilidade das cotas, hacker, reorganização, arbitration, que é a teoria da imprevisão. Qual que é a diferença entre taxa e imposto, entre DPO e encarregado, entre conciliação e mediação? Vamos dar sequência aqui à correção de mais uma questão. Esse projeto que eu estou me referindo é o projeto Carreiras Jurídicas, que é a de delegado da Polícia Civil. Cartório de protestos do Procurador de Estado, profissão de perito. Muito obrigado a todos vocês aí de casa, sejam bem-vindos ao canal Mais Direito. Já fica o convite para se inscrever no canal para você poder acompanhar todos os próximos vídeos. Um abraço e até o próximo vídeo.
Uninove is one of the top private universities in Latin America and the best private university in Brazil. Uninove's facts really impress. There are 10 campuses in the state of São Paulo and more than 100 distance education centers across Brazil, all equipped with the most innovative technology and infrastructure, built and founded on more than 60 years of history. Originated in 1956 from a typing school, and now became a reference for higher education in Brazil. We were awarded with the highest higher education, ranking Times Higher Education, as the best Brazilian private university in social impact. But for us at Uninove, the great prize for social impact is being able to insert over 200,000 students in the job market. It is also to develop partnerships with the most important companies in Brazil. It is also to foster education by offering full scholarships from early childhood education and to facilitate the entry of higher school students who cannot afford and wish to start a university degree. We also offer totally free English and computer science workshops. It is also to grant scholarships for the training of researchers and to be able to offer back to society all this knowledge. Our clinics also serve over 1 million people for free in health and family programs. We promote dental care, medical, psychological, and develop social programs that give full scholarships involving students in important social causes. It is also training and transforming people through education. Uninove, tradition and innovation in transformation through education.
Compartilhamos da certeza de que métodos adequados de resolução de disputas criam ambientes de negócio muito mais dinâmicos. Acreditamos em pontos de vista que, equilibrados, geram soluções mais justas e eficazes. Estamos entre as líderes no Brasil. Há 25 anos, trabalhamos para oferecer serviços ágeis e eficientes com custos de transação competitivos. Câmara de Conciliação, Mediação e Arbitragem Ciesp-Fiesp. Equilíbrio e celeridade.
Fala pessoal, tudo bem? Se você está vendo aqui pela primeira vez, meu nome é Franco Mazieiro.
Oi, Franco, obrigado pela pergunta. Olha, o especialista em direito aqui é você, não eu.
E esse é o canal Mais Direito. Não perca todo dia aqui no canal. Às 13 horas, programa Sexta com Direito. A gente vai conversar, a gente vai dar sequência para mais um O que é? Arras, TAC, divórcio, desconsideração da personalidade jurídica, Lei Geral de Proteção de Dados para Inteligência Artificial, startup, blockchain, guarda, recuperação judicial, técnicas de negociação. Você está acompanhando aí essa sequência de sugestões de temas de TCC, de monografia. Ontem nós conversamos sobre direito de família, direito e tecnologia. E hoje nós vamos conversar sobre direito penal, direito tributário, direito trabalhista, direito empresarial, direito constitucional. Eu queria uma aula com o nosso professor João Bosco do que é direito de concorrência, teoria do jogo e a arbitragem, direito societário, direito previdenciário, as cotas, a indivisibilidade das cotas, hacker, reorganização, arbitration, que é a teoria da imprevisão. Qual que é a diferença entre taxa e imposto, entre DPO e encarregado, entre conciliação e mediação. Vamos dar sequência aqui à correção de mais uma questão. Esse projeto que eu estou me referindo é o projeto Carreiras Jurídicas, que é a de delegado da Polícia Civil. Cartório de protestos do Procurador de Estado, profissão de perito. Muito obrigado a todos vocês aí de casa, sejam bem-vindos ao canal Mais Direito. Já fica o convite para se inscrever no canal para você poder acompanhar todos os próximos vídeos. Um abraço e até o próximo vídeo.
Uninove is one of the top private universities in Latin America and the best private university in Brazil. Uninove's facts really impress. There are 10 campuses in the state of São Paulo and more than 100 distance education centers across Brazil, all equipped with the most innovative technology and infrastructure, built and founded on more than 60 years of history. Originated in 1956 from a Taipan school, and now became a reference for higher education in Brazil. We were awarded with the highest higher education, ranking Times Higher Education, as the best Brazilian private university in social impact. But for us at Uninove, the great prize for social impact is being able to insert over 200,000 students in the job market. It is also to develop partnerships with the most important companies in Brazil. It is also to foster education by offering full scholarships from early childhood education and to facilitate the entry of higher school students who cannot afford and wish to start a university degree. We also offer totally free English and computer science workshops. It is also to grant scholarships for the training of researchers and to be able to offer back to society all this knowledge. Our clinics also serve over 1 million people for free in health and family programs. We promote dental care, medical, psychological, and develop social programs that give full scholarships involving students in important social causes. It is also training and transforming people through education. Uninove, tradition and innovation in transformation through education.
Compartilhamos da certeza de que métodos adequados de resolução de disputas criam ambientes de negócio muito mais dinâmicos. Acreditamos em pontos de vista que, equilibrados, geram soluções mais justas e eficazes. Estamos entre as líderes no Brasil. Há 25 anos, trabalhamos para oferecer serviços ágeis e eficientes com custos de transação competitivos. Câmara de Conciliação, Mediação e Arbitragem Ciesp-Fiesp. Equilíbrio e celeridade.
Fala pessoal, tudo bem? Se você está vindo aqui pela primeira vez, meu nome é Franco Mazieiro.
Oi, Franco, obrigado pela pergunta. Olha, o especialista em direito aqui é você, não eu.
E esse é o canal Mais Direito. Não perca todo dia aqui no canal, às 13 horas, programa Sexta com Direito. A gente vai conversar, a gente vai dar sequência para mais um O que é? Arras, TAC. Divórcio, desconsideração da personalidade jurídica, Lei Geral de Proteção de Dados para Inteligência Artificial, startup, blockchain, guarda, recuperação judicial, técnicas de negociação. Você está acompanhando aí essa sequência de sugestões de temas de TCC, de monografia. Ontem nós conversamos sobre direito de família, direito e tecnologia. E hoje nós vamos conversar sobre direito penal, direito tributário, direito trabalhista, direito empresarial, direito constitucional. Eu queria uma aula com o nosso professor João Bosco do que é direito de concorrência, teoria do jogo e a arbitragem, direito societário, direito previdenciário, as cotas, a indivisibilidade das cotas, hacker, organização, arbitration, que é a teoria da imprevisão. Qual que é a diferença entre taxa e imposto, entre DPO e encarregado, entre conciliação e mediação. Vamos dar sequência aqui à correção de mais uma questão. Esse projeto que eu estou me referindo é o projeto Carreiras Jurídicas, que é a de delegado da Polícia Civil. Cartório de protestos do Procurador de Estado, profissão de perito. Muito obrigado a todos vocês aí de casa, sejam bem-vindos ao canal Mais Direito. Já fica o convite para se inscrever no canal para você poder acompanhar todos os próximos vídeos. Um abraço e até o próximo vídeo.
Uninove is one of the top private universities in Latin America and the best private university in Brazil. Uninove's facts really impress. There are 10 campuses in the state of São Paulo and more than 100 distance education centers across Brazil, all equipped with the most innovative technology and infrastructure, built and founded on more than 60 years of history. Originated in 1956 from a typing school, and now became a reference for higher education in Brazil. We were awarded with the highest higher education, ranking Times Higher Education, as the best Brazilian private university in social impact. But for us at Uninove, the great prize for social impact is being able to insert over 200,000 students in the job market. It is also to develop partnerships with the most important companies in Brazil. It is also to foster education by offering full scholarships from early childhood education and to facilitate the entry of higher school students who cannot afford and wish to start a university degree. We also offer totally free English and computer science workshops. It is also to grant scholarships for the training of researchers and to be able to offer back to society all this knowledge. Our clinics also serve over 1 million people for free in health and family programs. We promote dental care, medical, psychological, and develop social programs that give full scholarships involving students in important social causes. It is also training and transforming people through education. Uninove, tradition and innovation in transformation through education.
Compartilhamos da certeza de que métodos adequados de resolução de disputas criam ambientes de negócio muito mais dinâmicos. Acreditamos em pontos de vista que, equilibrados, geram soluções mais justas e eficazes. Estamos entre as líderes no Brasil. Há 25 anos, trabalhamos para oferecer serviços ágeis e eficientes com custos de transação competitivos. Câmara de Conciliação, Mediação e Arbitragem Ciesp-Fiesp. Equilíbrio e celeridade.
Fala pessoal, tudo bem? Se você está vendo aqui pela primeira vez, meu nome é Franco Mazieiro.
Oi, Franco, obrigado pela pergunta. Olha, o especialista em direito aqui é você, não eu.
E esse é o canal Mais Direito. Não perca todo dia aqui no canal, às 13 horas, programa Sexta com Direito. A gente vai conversar, a gente vai dar sequência para mais um O que é? Arras, TAC. Divórcio, desconsideração da personalidade jurídica, Lei Geral de Proteção de Dados para Inteligência Artificial, startup, blockchain, guarda, recuperação judicial, técnicas de negociação. Você está acompanhando aí essa sequência de sugestões de temas de TCC, de monografia. Ontem nós conversamos sobre direito de família, direito e tecnologia. E hoje nós vamos conversar sobre direito penal, direito tributário, direito trabalhista, direito empresarial, direito constitucional. Eu queria uma aula com o nosso professor João Bosco do que é direito de concorrência, teoria do jogo e a arbitragem, direito societário, direito previdenciário, as cotas, a indivisibilidade das cotas, hacker, reorganização, arbitration, que é a teoria da imprevisão. Qual que é a diferença entre taxa e imposto, entre DPO e encarregado, entre conciliação e mediação? Vamos dar sequência aqui à correção de mais uma questão. Esse projeto que eu estou me referindo é o projeto Carreiras Jurídicas, que é a de delegado da Polícia Civil. Cartório de protestos do Procurador de Estado, profissão de perito. Muito obrigado a todos vocês aí de casa, sejam bem-vindos ao canal Mais Direito. Já fica o convite para se inscrever no canal para você poder acompanhar todos os próximos vídeos. Um abraço e até o próximo vídeo.
Uninove is one of the top private universities in Latin America and the best private university in Brazil. Uninove's facts really impress. There are 10 campuses in the state of São Paulo and more than 100 distance education centers across Brazil, all equipped with the most innovative technology and infrastructure, built and founded on more than 60 years of history. Originated in 1956 from a typing school and now became a reference for higher education in Brazil. We were awarded with the highest higher education, ranking Times Higher Education, as the best Brazilian private university in social impact. But for us at Uninove, the great prize for social impact is being able to insert over 200,000 students in the job market. It is also to develop partnerships with the most important companies in Brazil. It is also to foster education by offering full scholarships from early childhood education and to facilitate the entry of higher school students who cannot afford and wish to start a university degree. We also offer totally free English and computer science workshops. It is also to grant scholarships for the training of researchers and to be able to offer back to society all this knowledge. Our clinics also serve over 1 million people for free in health and family programs. We promote dental care, medical, psychological, and develop social programs that give full scholarships involving students in important social causes. It is also training and transforming people through education. Uninove, tradition and innovation in transformation through education.
Compartilhamos da certeza de que métodos adequados de resolução de disputas criam ambientes de negócio muito mais dinâmicos. Acreditamos em pontos de vista que, equilibrados, geram soluções mais justas e eficazes. Estamos entre as líderes no Brasil. Há 25 anos, trabalhamos para oferecer serviços ágeis e eficientes com custos de transação competitivos. Câmara de Conciliação, Mediação e Arbitragem Ciesp-Fiesp. Equilíbrio e celeridade.
Fala pessoal, tudo bem? Se você está vindo aqui pela primeira vez, meu nome é Franco Mazieiro.
Oi, Franco, obrigado pela pergunta. Olha, o especialista em direito aqui é você, não eu.
E esse é o canal Mais Direito. Não perca todo dia aqui no canal. Às 13 horas, programa Sexta com Direito. A gente vai conversar, a gente vai dar sequência para mais um O que é? Arras, TAC. Divórcio, desconsideração da personalidade jurídica, Lei Geral de Proteção de Dados para Inteligência Artificial, startup, blockchain, guarda, recuperação judicial, técnicas de negociação. Você está acompanhando aí essa sequência de sugestões de temas de TCC, de monografia. Ontem nós conversamos sobre direito de família, direito e tecnologia. E hoje nós vamos conversar sobre direito penal, direito tributário, direito trabalhista, direito empresarial, direito constitucional. Eu queria uma aula com o nosso professor João Bosco do que é direito de concorrência, teoria do jogo e a arbitragem, direito societário, direito previdenciário, as cotas, a indivisibilidade das cotas, hacker, reorganização, arbitration, que é a teoria da imprevisão. Qual que é a diferença entre taxa e imposto, entre DPO e encarregado, entre conciliação e mediação? Vamos dar sequência aqui à correção de mais uma questão. Esse projeto que eu estou me referindo é o projeto Carreiras Jurídicas, que é a de delegado da Polícia Civil. cartório de protestos do procurador de Estado, profissão de perito. Muito obrigado a todos vocês aí de casa, sejam bem-vindos ao canal Mais Direito. Já fica o convite para se inscrever no canal para você poder acompanhar todos os próximos vídeos. Um abraço e até o próximo vídeo.
Uninove is one of the top private universities in Latin America and the best private university in Brazil. Uninove's facts really impress. There are 10 campuses in the state of São Paulo and more than 100 distance education centers across Brazil, all equipped with the most innovative technology and infrastructure, built and founded on more than 60 years of history. Originated in 1956 from a typing school and now became a reference for higher education in Brazil. We were awarded with the highest higher education, ranking Times Higher Education, as the best Brazilian private university in social impact. But for us at Uninove, the great prize for social impact is being able to insert over 200,000 students in the job market. It is also to develop partnerships with the most important companies in Brazil. It is also to foster education by offering full scholarships from early childhood education and to facilitate the entry of higher school students who cannot afford and wish to start a university degree. We also offer totally free English and computer science workshops. It is also to grant scholarships for the training of researchers and to be able to offer back to society all this knowledge. Our clinics also serve over 1 million people for free in health and family programs. We promote dental care, medical, psychological, and develop social programs that give full scholarships involving students in important social causes. It is also training and transforming people through education. Uninove, tradition and innovation in transformation through education.
Compartilhamos da certeza de que métodos adequados de resolução de disputas criam ambientes de negócio muito mais dinâmicos. Acreditamos em pontos de vista que, equilibrados, geram soluções mais justas e eficazes. Estamos entre as líderes no Brasil. Há 25 anos, trabalhamos para oferecer serviços ágeis e eficientes com custos de transação competitivos. Câmara de Conciliação, Mediação e Arbitragem Ciesp-Fiesp. Equilíbrio e celeridade.
Fala pessoal, tudo bem? Se você está vendo aqui pela primeira vez, meu nome é Franco Mazieiro.
Oi, Franco, obrigado pela pergunta. Olha, o especialista em direito aqui é você, não eu.
E esse é o canal Mais Direito. Não perca todo dia aqui no canal. Às 13 horas, programa Sexta com Direito. A gente vai conversar, a gente vai dar sequência para mais um O que é? Arras, TAC, divórcio, desconsideração da personalidade jurídica, Lei Geral de Proteção de Dados para Inteligência Artificial, startup, blockchain, guarda, recuperação judicial, técnicas de negociação. Você está acompanhando aí essa sequência de sugestões de temas de TCC, de monografia. Ontem nós conversamos sobre direito de família, direito e tecnologia. E hoje nós vamos conversar sobre direito penal, direito tributário, direito trabalhista, direito empresarial, direito constitucional. Eu queria uma aula com o nosso professor João Bosco do que é direito de concorrência, teoria do jogo e a arbitragem, direito societário, direito previdenciário, as cotas, a indivisibilidade das cotas, hacker, reorganização, arbitration, que é a teoria da imprevisão. Qual que é a diferença entre taxa e imposto, entre DPO e encarregado, entre conciliação e mediação? Vamos dar sequência aqui à correção de mais uma questão. Esse projeto que eu estou me referindo é o projeto Carreiras Jurídicas, que é a de delegado da Polícia Civil. Cartório de protestos do procurador de Estado, profissão de perito. Muito obrigado a todos vocês aí de casa, sejam bem-vindos ao canal Mais Direito. Já fica o convite para se inscrever no canal para você poder acompanhar todos os próximos vídeos. Um abraço e até o próximo vídeo.
Uninove is one of the top private universities in Latin America and the best private university in Brazil. Uninov's facts really impress. There are 10 campuses in the state of São Paulo and more than 100 distance education centers across Brazil, all equipped with the most innovative technology and infrastructure, built and founded on more than 60 years of history. Originated in 1956 from a typing school and now became a reference for higher education in Brazil. We were awarded with the highest higher education, ranking Times Higher Education, as the best Brazilian private university in social impact. But for us at Uninove, the great prize for social impact is being able to insert over 200,000 students in the job market. It is also to develop partnerships with the most important companies in Brazil. It is also to foster education by offering full scholarships from early childhood education and to facilitate the entry of higher school students who cannot afford and wish to start a university degree. We also offer totally free English and computer science workshops. It is also to grant scholarships for the training of researchers and to be able to offer back to society all this knowledge. Our clinics also serve over 1 million people for free in health and family programs. We promote dental care, medical, psychological, and develop social programs that give full scholarships involving students in important social causes. It is also training and transforming people through education. Uninove, tradition and innovation in transformation through education.
Compartilhamos da certeza de que métodos adequados de resolução de disputas criam ambientes de negócio muito mais dinâmicos. Acreditamos em pontos de vista que, equilibrados, geram soluções mais justas e eficazes. Estamos entre as líderes no Brasil. Há 25 anos, trabalhamos para oferecer serviços ágeis e eficientes com custos de transação competitivos. Câmara de Conciliação, Mediação e Arbitragem Ciesp-Fiesp. Equilíbrio e celeridade.
Fala pessoal, tudo bem? Se você está vindo aqui pela primeira vez, meu nome é Franco Mazieiro.
Oi, Franco, obrigado pela pergunta. Olha, o especialista em direito aqui é você, não eu.
E esse é o canal Mais Direito. Não perca todo dia aqui no canal, às 13 horas, programa Sexta com Direito. A gente vai conversar, a gente vai dar sequência para mais um O que é? Arras, TAC. Divórcio, desconsideração da personalidade jurídica, Lei Geral de Proteção de Dados, da Inteligência Artificial, Startup, Blockchain, Guarda, Recuperação Judicial, Técnicas de Negociação. Você está acompanhando aí essa sequência de sugestões de temas de TCC, de monografia. Ontem nós conversamos sobre direito de família, direito e tecnologia. E hoje nós vamos conversar sobre direito penal, direito tributário, direito trabalhista, direito empresarial, direito constitucional. Eu queria uma aula com o nosso professor João Bosco do que é direito de concorrência, teoria do jogo e a arbitragem, direito societário, direito previdenciário, as cotas, a indivisibilidade das cotas, hacker, reorganização, arbitration, que é a teoria da imprevisão. Qual que é a diferença entre taxa e imposto, entre DPO e encarregado, entre conciliação e mediação. Vamos dar sequência aqui à correção de mais uma questão. Esse projeto que eu estou me referindo é o projeto Carreiras Jurídicas, que é a de delegado da Polícia Civil. Cartório de protestos do Procurador de Estado, profissão de perito. Muito obrigado a todos vocês aí de casa, sejam bem-vindos ao canal Mais Jeito. Já fica o convite para se inscrever no canal para você poder acompanhar todos os próximos vídeos. Um abraço e até o próximo vídeo.
Good afternoon and good evening, as we are doing all time zones in this conference. It is my pleasure to moderate the second panel of today on security, arbitration, and compliance. It's 3 topics, mostly the first 2, very, very important and really bringing the frontiers of law when it comes to dispute resolution. and it is my pleasure to introduce this stellar team of panelists, starting with Sui Yen Ko from Singapore. She is a partner at Wong Partnership there in Singapore. She focuses her practice on complex and high-value cross-border disputes. She has clerked in the Supreme Court of Singapore and has been involved in a number of initiatives there as a clerk, but also as amicus curiae, and has received for such a number of praise and accolades. She's also the vice chair of the IBA Arbitration Committee. She's member of the ICC Dispute Resolution Bulletin editorial board, and a few other. Please compliment if I have missed something, Swin.
It's fine, sure.
It's welcome. It's a pleasure to have you here, and thank you for staying late. We know it's late in Singapore now. Then moving on right to the United States, we have Catherine Rogers, who's a professor of law. She's at Queen Mary at the University of London. She's now on leave on the Penn State, and she's the founder and CEO of Arbitrator Intelligence. Catherine is a professor of law whose teaching and scholarship focuses on the intersection of professional regulation and market dynamics in international arbitration. She teaches, as I just mentioned, at Queen Mary at the University of London. She also co-directs the Institute of Ethics, Regulation, and Commercial Law. She's currently a visiting professor at Bocconi University in my dear Milano, and she's on leave on Penn State. She's the founder and CEO of Arbitrator Intelligence, a legal tech startup that provides unique, quantifiable, and contextualized data analytics for arbitrator selection. Among other appointments, Catherine is a reporter for the American Law Institute, Institute's restatement of the U.S. law of international commercial and investor state arbitration, and she was a co-chair of the ICA Queen Mary Task Force on Third-Party Funding in International Arbitration, together with Rusty Park, William W. Park. Okay. And then last but not least, and even more on a more aggressive time zone, now from Australia back to APAC, we have Guillermo Garcia Perrote, who is an international arbitration specialist based in Sydney, Australia. He works for a very renowned law firm, HSF. With deep understanding, he has practice and a deep understanding of infrastructure, construction, and energy. He also has experience in many other sectors in industry, like a wide range of trade, commercial, and financial activities disputes, including the T&M, M&A and joint venture, and financial sector. Guillermo is a regular speaker at conferences and seminars and lectures at universities and master programs in both arbitration and construction and infrastructure and energy sector. He publishes regularly on arbitration-related topics, including on smart legal contracts and the impact of technological developments in dispute resolution. This hot topic and the main topic of this panel. Okay, with this stellar lineup, the best I can do is to give them the floor as soon as possible. It's just a matter of introducing the topics. We will, just in terms of dynamics, I will ask questions to all the panelists. Others will be free to comment. We'll jump in and comment on them. I will go in the order: Sui Yen, Catherine, and Guillermo, and then we will open the floor for questions from the audience. Right? I was just mentioning just before we started. I was in a class. I was teaching a class yesterday, and the topic was precisely frontiers of compliance. And the person we brought to speak, precisely relating, so the person in charge of ethics in digital ethics in a large multinational, and we're discussing precisely the topics of data protection and cybersecurity. Of course, it is one of the new frontiers, two of the new frontiers of law generally, right? But of course, and it is also in dispute in dispute resolution. Just to have a measure of how this is getting importance, all the new legislation that has been enacted across the board, from the European GDPR to the new Brazilian regulations, US regulations generally, the California Consumer Protection Act, and all those new legislation is flourishing, and enforcement as well. So on the one hand, we are facing new regulation all the time, but on the other hand, still the practice is still very incipient. So we're, to a large extent, we're navigating on uncharted territory. Okay, and for that, many institutions have been very effective or trying to charter this territory, specifically in the field of international arbitration. ICA has recently issued 2 very comprehensive guidelines, one for data security, cybersecurity, and the other one for data protection. And we see there the intricacies of that, and all how you have, I mean, in an international context, how you can have overlapping regulation, how you have extremely extraterritorial regulation, like the European GDPR, I think by excellence is one of the most aggressively extraterritorial regulation we have in data protection, and how they overlap, and how they can overlap and come and clash in a simple context, in a context of international arbitration, where you have an institution in Europe, an arbitrator sitting in Latin America, another one sitting in Australia, and parties sitting in other countries as well. They all come together, and I mean, we have to be mindful. There's a new normal out there, and we should be able to navigate. And I think with these 3 panelists will help us shedding light in 3 different aspects of that at the end of the day they converge and will shed light. And this will be one more, for sure, this panel will be one more contribution to chart another bit of this this new territory. Just to give you, and just a matter of how important this can get, we're just discussing the fines that have been imposed over the last few years on the grounds of violation of cybersecurity or data privacy. Okay, and now let alone the $5 billion imposed to Facebook. I won't even touch that. But Uber had a 148 million fine. British Airways is still in the making, but British Airways so far, the discussions are around $230 million in fines imposed by the British regulator, and we have $275 million by Equifax, which is a major scandal in the US, where a lot of financial information has leaked. So it is uncharted territory, but it may be dangerous. So, I mean, there are sharks in this ocean, okay? So we should be mindful of that. And with that, now that I scared everybody enough, let's go to Sweden. The first question that I would like to ask you: what are some of the measures you have adopted in your international arbitration practice to deal with cybersecurity issues?
Martin, thanks very much for that introduction, and I'm very delighted to be here. Brazil time 10 a.m. It is 9 p.m. Singapore time. I think that is actually a difficult question, but unfortunately it's caveated because it says what are some of the measures that we have adapted. I think the key point actually is first to sort of lay down the framework for what do we mean when we actually talk about cybersecurity issues. And cybersecurity actually is extremely sort of wide. So it talks about the practice of defending your computer, your mobile devices, your palm health device, your servers, your electronic system, your emails, your network, your general data that you're holding on from any malicious attack. So one can imagine that if you talk about cybersecurity issues, putting it aside from international arbitration practice, cybersecurity issues is something that every firm, every company has to deal with, and also every individual who owns a mobile phone. So when we look at it this way, it actually means that it is an issue that is close to heart for each and every one of them. And when we then look at how this becomes even more pertinent when it comes to international arbitration practice, is because we are not just simply speaking about information that we receive as a firm, which belongs to the firm as our law firm, but we are receiving privileged and confidential information from the client. And the privileged and confidential information, and in many jurisdictions where they actually believe in this concept of legal privilege, litigation privilege, the clients would share with you in absolute honesty and candor what exactly it is in their respective positions, whether is it on certain documents, in their email communications, but it is in a sense there for everyone to see. And all these communications that the clients share with you in meetings, perhaps that's protected, but a lot of times these communications are shared over the emails. And this, I think, from a sort of law firm's perspective, is the greatest threat. The possession of information, privileged and confidential information that belongs to our clients and not ourselves. And so what first as a firm, I think, are some of the measures that we have adopted. And then I turn to what about specific to international arbitration practice. So as a firm, we have many MNC clients, and I'm sure it's the same with many of you, that actually mandates us to have standard minimum requirements to ensure cyber security issues are, in a sense, mitigated against. No one can ever say that there can be 100% protection against cybersecurity and against malicious attacks. Many governments have been the subject of malicious attacks. Even the Permanent Court of Arbitration's website, in that critical period when there was the disputes between China and Philippines over the maritime border, there was a hacking incident into the Permanent Court of Arbitration website. So I think no one is immune to this attack. But what we can do, knowing that these attacks are there, is to sort of adopt best practices. So as I was saying, so as a firm, I think we have actually implemented a very, very strong firewall. We have implemented very secure email systems, and we have also implemented secure file sharing system. So in a sense, and this is a process and a number of malicious threats, according to what I hear from our IT department, is actually pretty astonishing, because right as we speak now, our system is constantly being attacked. So even as I'm speaking to you right now, our email system is being attacked by virus, by interference, and because of the firewall and all the security measures they put in place, it actually there's a certain wall. That is not to say that the wall is cannot be penetrated, but that I think is the minimum. So I don't believe in a situation where you could simply just do nothing. I think there needs to be at least a minimum standard of firewall and a minimum standard of security from the firm's organization. But this is where we are speaking of where a player in the international arbitration market actually say, has that business or structural framework to be able to provide such measures. But the difficulty comes, and I think the difficulty comes when in an international arbitration practice, there are many players in it. So when we talk about international arbitration and we talk about the people who are involved, you have the counsel, you have the clients, you have the arbitral institutions, and you have the arbitrators. And I think that the problem with, in a sense, with the sort of diversity and the diverse players is that you are only as strong as your weakest link. And because of the fact that you are only as strong as your weakest link, as long as there's any one sort of failure in that loop and in that information sharing, then that becomes a real problem. It is not as bad, I would say, as compared to a law firm system which is being attacked. Because you will see the privilege and confidential information coming to a law firm. Yes, you will see that privilege and confidential information coming to what is being exchanged between parties in an arbitration. But that is not to say that that information that's being exchanged in the arbitration is therefore not confidential. Putting aside those cases for which there is a public hearing or which the rules of transparency apply, generally for commercial arbitration, confidentiality is key to our clients. And in certain disputes where it concerns very sensitive matters, for instance, defense contracts that relates to a very specific sort of energy dispute, there are a lot of confidential information to be preserved. So in that context, and when we as counsel, we would say and we would ask the tribunal to consider using certain secure file sharing systems. So that's the one thing we do. We propose certain secure file sharing systems to actually share the files when parties exchange their pleadings, parties exchange their documents. But I have to say, it has always been very difficult coming from a counsel's perspective, because it is not something that in my practice has become the norm in international arbitration as of yet. So I feel that depending on the counsel and depending on the counsel's firm's practice, it varies from firm to firm, counsel to counsel. But the problem is that not everyone sees and not everyone appreciates that this is actually a real threat. And not everyone appreciates how any drop in that link, any weakest link would actually undermine any cybersecurity measures that anyone in this chain has put forward. Even just the simple fact of an arbitrator sending that information on or allowing that information that's exchanged or that's part of the arbitration record to be accessed by a tribunal secretary who may himself or herself be assessing this on a device that is totally unprotected, that uses, for instance, public Wi-Fi. That is another area where it's extremely vulnerable, the use of public Wi-Fi, because that allows anyone to access that information. So that then creates a problem. So for myself and for what is it that we do? So we do our best as coming from a counsel's perspective, we ensure we have secure file sharing. We ensure that our emails, to the extent that's necessary, are encrypted. We do what we can from our perspective. But what I feel is that in international arbitration practice, that is not enough, because we are not the only players. So unless this is something which becomes much more of an issue that's confronted at an earlier stage of a proceedings, and an issue that is being confronted or perhaps taken upon by the arbitrators and arbitral institutions, I'm afraid whatever measures we adopt will still not be sufficient to address this issue.
Okay, thank you very much. It was a very comprehensive take on the issue.
I don't know if Guillermo or Catherine, you want to add or complement something here?
I'll go ahead.
No, go ahead, Catherine.
So I think the topic I was going to take up next is one that would probably complement this, and that's as I think, first of all, I think Sui Yun did an excellent job of explaining why it's important that we all pay attention to this. It's not, if anyone drops the ball, in a sense, everyone's then at risk. I thought she did an excellent job of emphasizing that. As we're talking about everyone together, I think it's also a message everyone needs to hear. So I wanted to start actually my first comment by thanking the organizers for including me in this, and also complimenting them. I do think this is, we were saying right before we went live that, you know, a panel like this with someone from Australia, Singapore, Brazil, and the United States would be extremely difficult to bring together in person. And so one of the very few silver linings of the virus is that these conferences are, it is now standard to have them online. And it means, as I understand, not only that we are pulling together speakers from all over, but also an audience that is huge. I don't know that we could get all these people in one room, from what I understand in terms of the attendance, and certainly they wouldn't all be able to fly to beautiful Brazil. So to the extent this is a message, and these are really important practice developments that everyone should hear, this is really a great format to be presenting that. So I'm going to hold on to my other comments about the ethical side, sort of complement to what Sui Yen said, until we move on. But I wanted to just pass the baton to Pierre now.
Thank you so much, Catherine. And again, also thanks to the organizers. I think it's wonderful to be part of this Congress and this panel, and muito obrigado to everyone in Brazil for organizing this. It's great. I think Sui Yen, again, did a great job in emphasizing how important this issue is. And in a way, we're all becoming more sophisticated. And as Sui Yen was explaining, probably law firms are at the forefront, and rightly so. So we are implementing practices that are probably above where the rest of the players are at this point in time. And she made a good point in noting that everyone else should take this issue very seriously. And I do think that lawyers, we play a very key role here, not only in implementing the measures, but actually in making sure everyone is thinking about these issues. And you really see that happening now, because clients are increasingly very worried about this, and they're becoming much more sophisticated. And we don't necessarily have to do an analysis of what the main companies are doing. Just on a day-to-day basis, you can see from across the board, companies doing much better. And small steps such as document retention policies and making sure that every employee understands how critical proper functioning of information is, to more sophisticated, obviously, firewalls and so on. And I guess one of the points that Sui Yen was emphasizing, and rightly so, is that in arbitration, every player is important. So what an arbitrator does, what the arbitral institution does, is as key as what the law firm is doing on the client. And in that regard, I'm sure Sui Yen will go over some of the recent protocols by ICA and the New York Bar Association, and some of the initiatives that we're trying to implement in the international arbitration practice. But yes, just to emphasize, I do think we play a very important role here in making sure that our clients, the arbitral institutions, and the arbitrators themselves are taking this issue very seriously, of course.
Thank you very much. Just two data points on the audience is we have people enrolled from 23 different countries for the seminar. We have had so far 7,000 single attendances in the panels, with average of a few hundreds. Of course, there's always a floating audience, but we're having a very good attendance to the panel. That's only possible in 23 countries because of this format. And by the way, it's important to mention that this panel is part of the Legal Week of Uninove, which is a university here in São Paulo. Okay, and well, just speaking on the points that have been very well highlighted by Sui Yen and Guillermo just now.
you have a very good phrase. You're as strong as your weakest link, right? If somebody drops the ball, as Catherine said, I mean, it's almost like a house of cards. House of cards. So, Suyen, how do you deal with the divergent attitudes and practices adopted by the various players, individuals involved in international arbitration process to cybersecurity issues? How do you deal with the weakest links? Or
Well,
the divergency of the diversion of standards?
I understand. So you see, that is where I feel that at least from the various arbitrations that and right up to the most recent hybrid remote hearing arbitration I had at last week, that very little has been done to deal with the diversions, attitudes, and practices that's adopted. I think many of you, including the audience who have been recently involved in arbitration, doing case management conferences, doing procedural order number 1, number 2, number 3, will not actually hear anything about whether is it the arbitral institution or the arbitral tribunal imposing or expecting any cybersecurity measures. I mean, at least for mine, and I have not come across any of the arbitral tribunal or institution taking the initiative to do so. Which means that effectively what we see out in the international arbitration market is to each his own. So each and every one of us adopt the approach that is deemed appropriate, which is why you will still see arbitrators using Gmail accounts, Hotmail accounts, which are extremely, not secure. I mean, when you are in an arbitration hearing, and let's say you are sitting as an arbitrator, every single confidential information gets sent to that account. I mean, that really, it's not regarded as a secure account. But you don't see, as of this date, despite the fact as to how serious these cyber attacks actually have been, when we look at all the attacks against the government, you don't see this changing as of yet. And I think the reason why you don't see this changing as of yet is because, if I can put it this way, the attackers and the cyber attackers they have found some cases where they wanted to do it for personal benefit. Often it is the counterparty on a particular case, and then the tribunal may make certain decisions, but people haven't found that important case enough to actually have an attack. But once it happens, and even it may happen without even parties knowing it, with competitors being able to attack certain arbitrations that they know are ongoing and to be able to steal that information. The question then becomes who then bears that responsibility and that liability when everybody is adopting their own approach and own attitude to dealing with cybersecurity issues. Which is why, in this respect, I actually feel that to deal with this really huge divergence in the attitudes, the sort of guidelines that Martin mentioned at the start, where he mentioned that the ICA, NYC bar, and the CPR, they came up with a protocol on cybersecurity in international arbitration. I think they launched this during the New York Arbitration Week, and that's something that I think everyone can access online. But I think that is certainly something that people who are practicing in international arbitration should actually take a look at. They should take a look at and they should consider whether in their respective practice and their respective international arbitration, are there certain practices and certain sort of baseline security measures that should at the very least be implemented in the arbitration at the very first case management conference, in the very first procedural order number 1. Certainly, I'm not suggesting that every single measure in this protocol be adopted because, to be honest, it is extremely wide-ranging. But I think there are little baby steps that could be taken. There are little baby steps that could be taken. They sought to do something in this protocol when they talk about the baseline security measures. They list out what could be some of these baseline security measures. But I think still there's a lot more work to be done because some of these are too vague, too general. But if the tribunal takes an active step, and if the institution takes an active step to actually ensure that there's a control to sort of the people who have access to these documents, there's a control to the documents that's being stored with the institution, and that there's a deliberate attempt to make this an issue, I think things actually would change. Because really, at the end of the day, when the attack comes and the information get leaked, the question really is, who is the one liable? And that's when they look at each and everyone's practice and they identify the weakest thing. So from my perspective, I certainly feel that arbitrators and institutions can do very much more.
Thank you very much. This is quite an important insight. Guillermo, any comments on that?
Yeah, no, I thought that was great. Yes, if I may add, I agree with that, but I would emphasize that arbitration is very much a user-driven process, and the client should be king, and we as lawyers are representing the client. So if we put the bar very high, and at the beginning of the process, we request that the arbitral tribunal takes this into account, and we engage with opposing counsel and put this at the forefront of the arbitration. And that push can come from the client, the lawyer, or ideally both. That's going to, I think, drive everyone to best practices. So what we're describing, I think now, is we're at a crossroads. Just a few years ago, a few months ago even, no one discussed this, right? Now we're starting to have conversations about it. That's good. Then we're going to get better and better. And the users, who are becoming much more sophisticated on cybersecurity anyway, and who are going to demand that us as lawyers and the arbitrators take the appropriate measures, I think are going to drive the process forward. And as I see it, maybe arbitrators and arbitral institutions are not going to take the initiative right now, starting from point zero. But if in every arbitration where the client is sensitive about these issues, in every arbitration where there's really a need to address these issues from the get-go, if that gets put in front of the tribunal is going to address it. They're going to have to. They're going to have to address it. So in a way, I'm very optimistic that we're going to take more and more steps in the right direction. And you know, the weakest link is going to be stronger and stronger as we go along.
Oh, so all we hope, just one point there, I think you emphasize a very important point, which is the users pressing it in from. And I used to be in-house lawyer for a few years in my life. And one thing that always struck me and still strikes me today, despite of all the efforts being done to the country, is the users community. The clients is still very, there's still an unheard voice in the community. Of course, this is changing, but in terms of, say, you have initiatives as the corporate, I used to be a member there. It's the Corporate Council International Arbitration Group, which is based in England and France. We have very sophisticated players in the user community, very well trained lawyers over there, but still they account for a minority. I think this is, and you're rightly so, and that's perhaps one more reason to be more inclusive with the users community, even more than it is now. So it's one more reason to do that. Just a side, as a side comment, to agree with you. Catherine, you have any?
Well, first, let me emphasize, I absolutely agree that I think what happens when the users stand up and say they need something, they want something, is that the arbitration community, in fact, responds. They shouldn't wait for that. As attorneys, as institutions, as services, we should anticipate what our clients need and respond with proposals that they can then adopt. But perhaps the strongest way that users enforce, express their needs here is actually an arbitrator selection. And it's a little bit of a preview of what I'll talk about later. Arbitrator intelligence is a service to try and augment the kinds of information and the useful kinds of information that parties have access to when they're selecting arbitrators. And we are getting lots of requests to actually amend our arbitrator intelligence questionnaire, which is how we collect information, to include questions that have become all of a sudden relevant, like what is the skill set of this arbitrator in using technology? Were they effective in this past case in use of technology? Cybersecurity also. Did they, in procedure order 1 or 2, actually signal that they had a concern about cybersecurity? Did any cybersecurity breaches come up in the case? Particularly, and I'll get to this, but with regard to evidence, right? If they're, one of the reasons why different parties have, in some of these historic cases, hacked governments or the PCA was to not just, obtain the evidence, but in some instances to try and introduce it into the proceedings to be used against the victim of the hacking. How did arbitrators respond to that? It's not always a completely straightforward and clear question, because in some instances, for example, the hacked information might reveal that the victim was itself presenting false or fraudulent information. And so in a sense, you don't want to reward one side or the other. So some of these questions become quite complicated for arbitrators to work through, but they are coming up. They're going to come up more frequently. And the best way or the most effective way that parties, the clients, can ensure that their interests are being taken care of by arbitrators is actually in arbitrator selection. With regard to counsel as well, though, one of the things I thought both Suyen and Guillermo emphasized is how much personal responsibility there is here. I mean, when we have these complex regulatory schemes that impose penalties, they tend to be focused on the firms, the institutions, these organized structures. But all of these regulatory forms through what we call hard law also have an ethical, essentially soft law counterpart. And we're seeing some more development of those in international arbitration. But there have also just the existing rules are being applied. So, for example, all ethical codes have obligations for attorneys to maintain their client confidences. But how that obligation to maintain client confidence is interpreted is changing, even if the words in the regulation in the ethical code haven't changed. So, for example, there was in a domestic context, there was an attorney who sent a sensitive confidential client document via Dropbox, and the Dropbox was hacked. And that attorney was actually sanctioned by their bar association for being, as careless as chatting out loud on a train or in a cafe, your client's confidences, right? Now it's a matter of entrusting those confidences to an unreliable, a context that's unreliable in that sense. The other thing I think it does, and there was a really, we actually almost daily get these reminders, but not as colorful or troubling, I guess, as one recently involving a retired judge who certainly should have known better, and a truly reprehensible case. But the risk of cybersecurity hacks also, I think, should make us all much more attentive to the kinds of things we communicate and what we think is private. So there was a case involving a very high-profile case, and it was a JAMS arbitrator who accidentally sent what was a hideously racist joke to actually both opposing counsel, both counsel accidentally in a listserv, meaning to share this racist joke with apparently his golf buddies who would have found it funny. But one of the things that when I teach ethics, which I do in U.S. law schools, is I tell my students, don't say anything that you wouldn't want to see on the front page of the New York Times. And that used to be hypothetical in case you hit the reply all accidentally instead of just reply. But these days, it's also if you get hacked, right? And it's one thing to say something that's embarrassing to you or yourself. It's another thing, for example, to express things that would be incredibly damaging to your client if they were to become public, if they were to be hacked. And well, we all sit and think, okay, well, I'll just follow what Suyen said, and we'll be careful, and we'll have lots of firewalls, and we'll be protective. When I heard the presentation of an earlier draft of what became the New York bar's new guidelines on this, the person started by saying, the question is not, if you will be hacked or when you will be hacked. You've been hacked. And that, just sent chills up my spine, because we have all been hacked. It's a question of what people do with it, and when it will essentially be used, or whether they, what kinds of information they were able to get. But no matter how protected we all are, including the U.S. government, and highly protective, secretive aspects of the U.S. government have been hacked. So I think it's also a reminder to us when we're thinking about our ethical obligations to be concerned that, if we did get hacked, if we did get surveilled, if we did get, if we did accidentally ourselves, in a sense, send something to, as more and more is online, the mute button may accidentally not be on. The email that hit reply all, we've all kind of had, hopefully not embarrassing, but incidents where we meant to just reply privately. But what these do create is a need for us all to individually, as individual lawyers, be attentive to the needs of our clients and their confidentiality, and not just rely on compliance with hard law by our law firms.
Okay, thank you very much, Catherine. This is actually the perfect segue for a few questions to you. First, as a preliminary, would you like, you already spoke very proficient, of course. You are a professor of ethics. Would you like to elaborate a little bit more on what are the actual ethical obligations for counsel and arbitration with respect to cybersecurity, or should we already switch gears to arbitrator intelligence, which is a fantastic initiative as well?
Yeah, I have trouble restraining myself about arbitrator intelligence, because it is, for those of you who know me, my passion project. But what founded it, actually, I will say the two go together, is I really, our core values as an entity are transparency, accountability, and diversity. And I think that those are, to me, ethical obligations or ethical principles. They start as ethical principles. So for me, it's really important that we have an organization that is committed to those values. And it was started as an NGO, where its only activity was to promote those values. We've become commercial because we had to, out of necessity, to be able to scale up and to be able to do what we wanted to do. But we remain committed to those. And I think that those. One of the things that I think is probably most relevant in there is transparency and accountability. But I think that those two naturally lead to diversity. So if you don't mind, I will borrow the time to just explain a little bit about what arbitrator intelligence is, because it's relevant to this panel, most importantly, because what it is doing is bringing technology to link together all the stakeholders of the arbitration community in a way that they can exchange in a secure and confidential way, information that needs to be shared to increase transparency, but otherwise cannot be exchanged. So when we're searching for arbitrators, when someone wants to appoint an arbitrator today, the primary technology they use, two technologies are Google, because you search for them everywhere you can, and you come up short because there's not very much publicly available. So then you use your email and you send out a request to people in your community, in your professional network, and say, have you ever heard of this arbitrator? Have you ever appeared before them? Have you ever sat with them? Okay. Now, most people will not send an email back, and that's kind of relevant to cybersecurity, because they don't want to risk that the email be forwarded to someone else or become public somehow, where their views, their kind of confidential, sensitive views about an arbitrator might become publicly available. So they usually use 19th century technology. They pick up the telephone and they have telephone calls about arbitrators, about their experience with them. And the problem with this is multifold. And I'm especially happy to be talking about this to a, as I understand, predominantly Latin American audience, because it is a problem, and where I started with this is fairness. It isn't okay, I think, to try and constitute a so-called fair tribunal if one party and their counsel have access to a huge professional network where they can get a lot of information about an arbitrator, and the other party is limited or doesn't have anyone that they can call. So fairness is another thing that I think is part of the ethical foundation and the inspiration for arbitrator intelligence. What we do is we do use technology. So it's a relatively simple technology in many ways, sort of like the Uber app is simple, or the Airbnb website or app is simple. It basically connects people who have information with people who need information. They essentially are the same people, just at different stages of the proceeding. And what it is it's an online questionnaire called the Arbitrator Intelligence Questionnaire, or AIQ. And the questionnaire does not ask for confidential information, such as the parties' names. We've been encouraged to ask for the party's nationality, but we were very conservative in the beginning and don't even ask for the party's nationality because some people thought that might be a little too revealing or sensitive. But we ask all sorts of other detailed information about the case. Obviously, the names of the arbitrators, the amounts, the dates, all that. So to the extent that timing has been a big issue and a concern for people, we can show you how long the arbitrations take. We can also, because we collect it this way, not through phone calls, we can also analyze that data. We also ask a number of questions about the arbitrator's rulings, which even if you had the award in the case, you wouldn't be able to know how much document production was requested, how much was granted, was interim relief sought, so was it granted? A lot of times that's not available except for talking to parties. We also ask about their methodological reasoning, how they analyze things, how they treated damages issues. And most importantly, we also ask a number of evaluative questions from counsel. Did they think the document production was too much or too little for the size of the case? Did the arbitrator render an award that they thought was persuasively written? To me, one of the best endorsements of an arbitrator, and we've found many of them, is when a losing party identifies the award as persuasively written, because that signals that you have a losing party that's probably more inclined to comply with the award, and that feels like the process was fair, which I think is a win for everyone because it reifies the legitimacy of the system. As I said, we're being encouraged to expand some of our questions. We'll be coming out with AIQ 2.0 in the fall, so watch for it because we will be posting it for public comment. Because one of the things we found, this is I would say a project that brings together everyone in the community to build something for the community. So the AIQ was created by surveying and getting input from hundreds, of over 500, I would say, council, parties, members of arbitral institutions. Once we come up with the 2.0 version, we will also be posting that for public comment because some of the best insights we get really are from people who are outside our organization, but who give us comments. And that's, again, one of the benefits of technology that we can do is post, it's something that by now that's very familiar, but it brings together people in a way that is now, kind of invisible to us because it's right before our face. But I think it's really important in such an international context as international arbitration to confirm that that's also a way to promote diversity, right? Because if you are limited to physical interactions, it shrinks the network of people who interact. It makes it harder for newcomers to become known, to be seen. And I think that's really where diversity comes in. So I see technology like this conference online, technology like arbitrator intelligence, as mechanisms for also promoting diversity and an arbitration community that is much more sort of in touch with each other and being able to share important ideas in real time.
Excellent. Excellent. Any comments from Guillermo?
Very interesting. No comments so far.
I wanted to say that I actually think that it is a great project, and I think it really does help to even the playing field when it comes to a question of the selection of arbitrators, and it does put all this information there. So as that idea of that project, I think is a great project. But as a arbitration practitioner who has sort of practice and everything, so one of the key sort of skills, or one of the key reasons why sometimes your clients come to you is simply because you have that extra intellectual capital and that extra thing that gives you an edge over your other competitors in the market. So obviously, that is something that increasingly with such material and such transparency, that edge will no longer be there. But that's not something that I'm worried about, because to me, I always believe that with that better even and better playing market field, when it becomes there, you can always find something else to value add. So it's not that it's a project that I am for when it comes to the underlying purpose of it. Yeah.
Thanks. I will say, when I first started, and I started many years ago, I had law firms, some very prominent law firms tell me to my face, we hope your project fails because this is the information we sell to our clients and we don't want the competition. To me, I much more respect Sui Yin's position, which is I can handle the competition. And let me tell you, no matter how much information we provide, there will always be something that can be added by intelligent counsel. So we are working with data. We present, data analytics, and sometimes our data is not fully representative, and the council will know that and be able to explain that, but they'll be able to add nuance to the interpretation of our data. So council's expertise will, I think, be enhanced by this new tool, not undermined. And just to be perfectly clear, I mean, council's number one goal is to pick the best arbitrator for their client. And to the extent that this tool can increase predictability and precision, then attorneys should always, I think, be in favor of it. And if the only thing, to be honest, and I also picked this up in what you're saying, Sui, is, if the only thing you can do to attract clients is kind of have this secret information that you withhold and charge them, a surplus for, then you need to be a better lawyer, right? Good lawyers shouldn't be afraid of this. They should embrace it, I think, as a new tool to help them do their job better, and to serve their clients better more than anything. So I do think clients are the ones who are the primary beneficiaries of this new innovation. And hopefully, because again, we rely on people giving us data, right? Sharing their feedback about cases with us. So I'll just pause to say that one of I think the entities that have the greatest incentive to encourage people to do that are the parties, because we collect their information in a respectful and confidential and secure way, but we allow them to share it with others in a way that you could not over the telephone, either because you don't know all these people. You couldn't, through telephone calls, produce the kind of sophisticated analytics that we do. Or you might not. I mean, even one of the things we're seeing actually is increasingly an increasing number of smaller boutique firms coming up, and I think that that's a really important, healthy part of globalization of the legal profession. It's an important part of diversification, right, of the legal profession. But it also means that you have smaller firms that might not be as connected. They're very talented lawyers, but they shouldn't be disqualified from effectively representing their clients simply because they don't have the social network to choose arbitrators. So we think of this as a way to empower firms, including, from the top to the bottom, which we think is really good for everyone in international arbitration, most especially for the clients who have the most to benefit. And I'll just say one last thing on that, which is, and I do see this also as an ethical issue, is it allows, our tools will allow, our reports allow in-house and outside counsel to discuss and debate arbitrator choices more effectively. Because right now what happens is the attorneys sort of collect this information because it's ad hoc and sort of storytelling like. It's very hard for in-house counsel to enter into a meaningful debate with them about which ones they prefer. When you see our reports and how they're organized, and you can go to our website to see that, arbitratororintelligence.com, you see that it creates a structure for increased also strategizing between in-house and outside counsel about what aspects of their case strategy should they prioritize in selecting arbitrators. And I think that again is part of an ethical obligation that counsel have, which is to facilitate meaningful communication and discussion on what is the single most strategically important moment in the case. So with that, I can go on forever because I love this project, and I'm sorry if I talk too long, but thank you for giving me a chance.
Just to add there, Catherine, and to reinforce some of the points that we've been making, definitely it's a very critical time, a very important and crucial time of the arbitration and the advice we provide on the selection of the tribunal. So no, I would definitely agree. I don't see this as a threat in any way to the value we add. For example, we at HSF we have 27 offices worldwide. We take this process very, very seriously of making sure that it's a very nuanced process. So we're talking about a lot of different issues that go into the arbitration selection process. It can be as nuanced as seeing if someone is a black letter law. It can be as nuanced as saying, what is the tribunal going to look like? Are we going to have civil law, common law? What kind of contractual issues are going to be addressed here? What kind of contractual positions will typically favor our clients? So the conversations we have are quite sophisticated in that regard with our clients, and I feel quite strongly about the value we add there, and the fact that this in no way is incompatible. I think more information at every level is always interesting for everyone, and that's not going to change, I think, our conversations with our clients, and so in that way, I don't see it as competition or a threat. I just see it as a very interesting project that sounds wonderful for sure.
Okay, very well. Yeah, I'll refrain from commenting on this one because I consider myself biased, as I'm a fanatic for empirical studies in the legal field. I did part of my PhD on that. I love this type of research, so of course this is a very welcome innovation. I think, of course, technology is there for help. It might, but the more information, the more data points you have to make your decision, the better. And I could not agree more that it doesn't. I don't think it damages in any way the work of the law firms in guiding clients and users on the selection of arbitrators. Actually, it improves because the more data points you have. And here's the thing on, and we're talking in a university, when you talk, one thing is proper empirical results, the other thing is relying on anecdote. Okay, you can, there are only so many drinks in your gentleman's club that you can have with a very famous arbitrator that will give you insight. There are only so many arbitrations you can have, and then it will give a good insight, but still is anecdote. It's not hard data, right? Yes. Unless you quantify it, you have in a sufficient way to quantify it.
I'm going to say one more. Can I say one more thing really quickly? About the power of technology. I mean, right now we're in a big debate because there was a promise that technology would empower, would democratize, and we're finding that without proper controls, maybe it actually has instead a very negative effect. We are very cognizant of that all the time, but one of the ways that I think, and here I'm not speaking to big law or about big law, I'm talking actually to what I hope are a lot of people who've tuned into this, which are very small law firms that might have, this one of the results of COVID, I think, is we are going to see not only a spike in big cases, but also in the smaller, medium-sized cases. And those are the hardest ones to find arbitrators for. And in fact, we have a couple of institutions that if the case is below $5 or $10 million, they actually shift the tribunal from a 3 to a 1-person tribunal. It's very hard to have opposing parties agree to a single person, a chairperson, or a sole arbitrator, especially in these smaller disputes where the arbitrators tend to be ones that are newer, have had fewer cases generally, and fewer cases that might be publicly known. And so one of the things I'm most proud of actually in our repertoire is that we can do a report on a single arbitration. So we might have a younger arbitrator, a young woman from Brazil who's had her first appointment or her second and third appointment because institutions are now appointing her. But if no one's ever heard, if those arbitrations all remain secret, she has no reputation as a good arbitrator. So one of the things we can do is help newer, younger, less well-known arbitrators develop a reputation by making public their performance even in one arbitration. we don't have a lot of sophisticated analytics in that context. But what we do is we do allow a spotlight to shine on, again, newer, younger arbitrators. And that's a way that technology directly promotes diversity and creates opportunities for less well-known arbitrators who are the future of tomorrow, right? The way the big arbitrators start is they start in smaller cases. They might get their first appointments by an institution, okay, but then how do they grow from there? And so we're excited because I think technology will help in that process as well.
Excellent. Now let's switch gears and time zones to Australia. Is it midnight already there, Guillermo?
Midnight already. That's right.
Thank you. Thank you so much for being awake with us.
Anytime to make midnight or whatever. No.
Let's talk now about smart legal contracts, right? And Guillermo, let's start with what are the smart contracts and what is the difference between smart contracts and smart legal contracts?
Thank you so much, Martin. So what are we talking about? And I think it's important to differentiate the two concepts because there's a little bit of confusion in the industry on the way we discuss these two different concepts. So smart contracts are essentially contracts that include code, self-executing code. And it's basically using blockchain technology to automate part of the contract. What is a smart legal contract? A smart legal contract is a contract that has both natural language and code for executing certain parts of the agreement. So we can almost think of a smart legal contract as a second generation of digitalized legal contracts, which facilitate the automation of the performance of the contract. So in short, smart legal contract is legally binding, this is important, digital agreement, in which part or all of the contract is basically enhanced by a coded part of the contract that facilitates automation. So what are we talking about here? Does that mean that contract law is going to end and there's no room for lawyers? No, quite the opposite. There's always going to be the need to have a rule-based system to enforce and provide remedies for the parties. So a basic example to look at this would be, I always say that we're talking about the same issues with different technology. So what are the parties trying to address in a contract? They're trying to allocate risk between each other, essentially. And they're trying to, reach an agreement and facilitate a commercial bargain. And in that, they need a contractual framework to allocate risk. So, for example, I always find it quite useful to use a non-smart legal contract example to address this. In any kind of sale of goods that includes shipping, the parties have to decide at what point in time the risk passes from the buyer to the seller. How do we do this in practice? We normally refer to Incoterms, right? Does the risk pass when the goods leave the warehouse? Is it when the goods are being loaded on the ship? Is it when the goods are delivered to the purchaser's warehouse? So the distinction matters clearly, because if something happens to that cargo while it's being transported, whether you're facing the risk as a buyer or a seller can have huge implications, right? So in a smart legal contract context, the questions of risk allocation are quite similar. For example, if the contract includes code that results in certain actions being triggered based upon input from imagine a temperature or a humidity sensor, then the parties need to specify, and ideally in the natural portion of the text, as I will elaborate a little bit later, which party bears the risk if the code, for example, malfunctions because the sensor doesn't work, or is hacked, or you have a third-party provider that basically their system malfunctions. What happens in that situation? And how does the interplay between the natural language version of the contract and the coded version of the contract work? These are all questions that address that. Basically, we are dealing with risk allocation between parties using new technology, but we obviously, especially as the transactions become more sophisticated, need to address the way that the contractual remedies are going to work, and the way the parties are going to address the consequences of breaches, or the way the parties are going to address the consequences if things don't go according to plan. So none of this obviously is revolutionary. It's simply an extension of the normal allocation of risk between the parties, right? The difference is that additional risk and potential trigger points we need to be examined and addressed when we're dealing with new technology, such as blockchain. And I thought, just as an introductory remark, it might be helpful to address two concepts that some people may not be familiar with. One is so-called oracle. An oracle is basically a party outside of the contract, or not necessarily one of the two parties of the contract, that provides an input into the transaction. So imagine in my example before, when you have a sensor that checks the temperature and that triggers certain thing in the contract, sometimes you would need an oracle to provide that information. Or, for example, in a price revision mechanism, or in a transaction where the stock price of certain shares is important, and something happens when, imagine, a company reaches certain level in their stock market valuation. What benchmark are you using? Who is providing that information? That obviously highlights that there's going to always be, especially in complex transactions, an interaction between the coded part and the real world, right? And another example that I can provide is called multi-sig transactions, which is basically the way I like to explain this is when you have 2 out of 3 keys that unlock the next step in the contract. So you have 3 keys, and to unlock every step of the contract, you need at least 2. What does that mean? That means that if the parties are in agreement, the contract is going to continue executing. So if everything goes to normal, for example, in a supply chain transaction dealing with purchase of grain, and you have basically sensors that measure the grain, you have quality assessments with the results of a laboratory, and that triggers payment, that triggers insurance release. If that happens along the way and both parties actually accept the result and no one is in breach, then you have the 2 keys. If something happens in the middle of that dispute, where where a dispute arises because something malfunctioned, someone hacked the code didn't work properly, the service provider providing the technology didn't do their job, a party breaches, and there is a dispute there. What do? Well, you can resort to traditional means of dispute resolution, and you can also think of things like the 3rd key being held by the decision maker, and whether that's an arbitrator, an expert, or other decision maker, that's for the parties to decide. But this basically highlights that there's always going to be that interaction in the coded part of the contract and the natural language part of the contract and the dispute resolution mechanism that you choose. And just to finish with my preliminary remarks, why I personally think that arbitration, and particularly international arbitration, is well suited for the resolution of these disputes. Well, if you think about it, first, obviously, as always with international arbitration, enforcement is key, right? Pursuant to a New York Convention, you can enforce your award basically all over the world as if it was a national judgment, and that obviously it's a huge competitive advantage as opposed to litigation. Then we're dealing, and Catherine and Suyen were just discussing the selection process of arbitrators, right? That may be very important in a context where you're dealing with novel technologies and new ways of contracting, right? You want to make sure that you have the flexibility of choosing the best arbitrators for those kinds of disputes. Then obviously, third reason is you have a lot of flexibility to choose the rules applicable to the process, and you can really tailor your arbitration to the case. So obviously working with the counterparty and the arbitral tribunal, you can really tailor the process to make it as streamlined and seamless as possible. And then obviously, and then the fourth and very important one as well, is that you make sure that with an arbitration agreement from the get-go, you avoid any kind of jurisdictional issues and arguments about the right forum, and that could actually be quite complicated in digital context. So in short, smart legal contracts, very exciting development. I think we're going to see in the next few years more and more transactions start incorporating blockchain, and some people focusing on technology and engineers and designers will tell you that this is the end of contract law and that there's no need for decision makers, human interaction. I would say it's quite the opposite. I would say the role of contract law is going to be enhanced in the digital age, and you're going to see very complex and sophisticated agreements in place.
Oh, that will be one of my immediate reactions to that. What type of transactions I had when I was working in-house? We started to use some of those contracts, but we used it mostly for freight. We used that for a freight desk, which meant they were small contracts with very simple execution and repetitive. Okay, that was when we started. Do you see that? Also, I mean, is it expanding? Because I'm talking about 3 years ago already, 4 years ago. So do you see this evolving and getting to more complex types of contracts and therefore dispute resolution?
Very good point, Martin, because in the here and now, what's happening today is closer to what you described. So it's closer to being used in more discrete contracts and contracts that allow for repetition, basically, right? However, we are seeing a lot of more complex supply chains starting to test these contracts. And we're going to see definitely in the next few years more complex arrangements. So we have a very big spectrum, right? On one side of the spectrum, you can see a very simple escrow mechanism and dealing with a very, very mid-size, so low-size a transaction. At the other side of the spectrum, you may see a supply chain involving 10 players internationally, right? And that obviously is going to require quite a complex and significant framework, both from the coding part of the equation and from the natural language part of the equation. So what you're describing is easier, more repetitive transactions, particularly in contexts where there's really not much room for disputes or complicated disputes. And that's where you're already seeing this today. And where we are going to evolve, I think, is towards the more complex side of the spectrum, where the interaction between, let's call it the manual side of the real world and the coded part is going to be a little bit more tricky.
Very good. Catherine, Suyen, any comments on that?
The one thing I will say, and I commend Guillermo on such a comprehensive and comprehensible explanation of blockchain. I mean, one of the tools, well, one of the obligations I think we have as lawyers is to make these new tools understandable to our clients. So it was well done. I've heard several explanations, very few as clear and articulate as that. So I do think, again, as lawyers, you know, from the ethics perspective, you have an obligation to be well informed about what the options are for your client. And in fact, there have, at least in the United States, been instances where lawyers failed to advise their client on sort of an optimal or best practice use in their or an option that was available to them. So I think it's really it behooves us all to learn more and make sure we understand blockchain. And I think also it will raise some new challenges, but for right now, it seems like it can be, especially in the current environment, a way to secure things. I mean, some of the new disputes that are coming up, many of them are breakdowns in supply chain. And if these were instead blockchain transactions that had established definitions and protocols for what constitutes force majeure, and a lot of what are turning into live disputes today might have instead been a sort of resolved through a blockchain seamless transaction. So it seems like blockchain is something that will end up saving clients money and time, and will be really important. We also, I think we are facing globally, this is a little outside my wheelhouse and maybe the topic of the panel, but we are seeing increasingly backlash against global supply chains, and some people questioning whether supply chains should be renationalized. Clearly, this is a community, international arbitration, that doesn't believe that. I ultimately believe that a lot of the decrease in poverty globally wasn't exactly because of these supply chains, and to the extent blockchain technology could help preserve them, make them stronger, less vulnerable to these kinds of events, not just pandemics, but also other types of force majeure, major environmental disasters, so that they become part of the business process and the business cycle, as opposed to separate disputes that require lots of lawyers. And I know that's seems bad for our for lawyers who bill by the hour. They want always more disputes, but I think ultimately what they want is what's best for their client and the most efficient way to resolve these kinds of concerns, because that's what's going to keep globalization, I think, thriving. And that's and without that, none of us will have the kind of business and clients. So in that sense, I think blockchain is very promising, and it was really great. Again, thank you, Guillermo, for such a thoughtful and concise explanation of how it all works.
Thanks so much, Catherine.
Soyin?
No, I mean, I have nothing further to add because Gerald has covered it very well and very thoroughly. So.
Okay, very good. Guillermo, how do you see the smart legal contracts impacting the dispute resolution mechanism, in particular IA?
Well,
how do you see them discussing the cybersecurity landscape as well?
So in cybersecurity, again, I think we are very much pushing developments from the user end, right? And the increasing use of technology, the increasing sophistication of our clients, the increasing sophistication of the way we address supply chains is only going to make this more of an issue at the forefront of any discussion, right? So in a way, I think it ties up well with what we were describing before. What are users going to be forcing institutions, arbitral tribunals, their own lawyers to learn and to develop? Well, first is understanding of the technology. Second is understanding of the threats that the use of this technology encompasses, right? And cybersecurity is definitely the main one, because when you are putting a lot of information, a lot of critical information in a coded part of a contract, that definitely should bring to the forefront of everything that you're doing. They need to have very, very strong protocols in place. So in a way, any dispute dealing with smart legal contracts, as I see it, is going to be by definition more sophisticated in cybersecurity. And users are definitely going to demand the arbitrators and the institutions to know what they're doing on that front. So imagine you are a company that has entered into a very big transaction with using blockchain technology. You're definitely going to want to make sure that any dispute resolution mechanism that you agree with the other side takes it into account. And that's where I actually see a few risks there, if I may, and not everyone may agree with me here, but I do think that sometimes when you are too into your own topic, into your own technology, you, for example, make the following assertions. One, I need an arbitrator that has expertise in code. Or two, I need to include all these provisions in my arbitration agreement. Well, I would say you need to be a little bit careful there, because one thing is to want the process and the arbitration proceedings to be, let's say, robust in cybersecurity. And the other thing is to constrain that process from the get-go, one, requiring a specialization that may not be very easy to get and actually may not be strictly necessary. And two, also trying to play and be a little bit too cute with your arbitration agreement. Those I think are things that I see users trying to do as well in this space, which not always work. And I try to always emphasize the need for clarity, simplicity, and no question marks around what the arbitration agreement is supposed to do. So people excited about technology, that's great. There is still a lot of room for us lawyers to make sure that we bring the best of both worlds, right? And another comment that I would make in that regard is many people get excited about the technology and all they talk about is the technology. Well, I actually see a lot of legal developments here. For example, implied terms. Courts, especially in common law countries, have developed implied terms for a broad range of transactions. Those implied terms are arguably not meant for smart legal contracts, or at least there's going to need to be an evolution in that regard. Or rules of evidence and the audit trail created by digital data. Is that going to need to change the way courts and arbitral tribunals address this issue? For sure. And I think it's going to be interesting to see the evolution of arbitration in this regard, because in a way you can see arbitral tribunals and scholars and practitioners pushing as well courts to consider this and not the other way around. So yeah, a few interesting issues to consider definitely in the future. Martin.
Excellent. Does anyone want to comment on that? Okay, so as we have a few minutes left, I think it's time for us to open to the floor to questions from the audience. So please, any questions, please do raise your hands. Oh, I'm just getting that so far known. And well, so if it's okay, so I'm just getting here that we're actually the chat is not open for that. That's the message I just got. So unfortunately, we won't be able to take questions from the audience. Okay, so I think we can call it a session. I would very much like to thank this stellar lineup of participants. It's been a pleasure and an honor to be with you today. I think you shed light on very important topics that are very different and yet intertwined aspects of technology in dispute resolution. I think it's I learned a lot, and I'm pretty sure the audience learned a lot as well. So thank you very much. Thank you for your time, and well, I hope to be in contact with you soon, and perhaps in another edition of this seminar. Okay, thank you very much.
Thank you for such a great job moderating.
Absolutely. Muito obrigado, Martin.
Moderating. Thank you.
Thank
you so much.
Just please stay. I think.
Uninove is one of the top private universities in Latin America and the best private university in Brazil. Uninove's facts really impress. There are 10 campuses in the state of São Paulo and more than 100 distance education centers across Brazil, all equipped with the most innovative technology and infrastructure, built and founded on more than 60 years of history. Originated in 1956 from a typing school and now became a reference for higher education in Brazil. We were awarded with the highest higher education, ranking Times Higher Education, as the best Brazilian private university in social impact. But for us at Uninove, the great prize for social impact is being able to insert over 200,000 students in the job market. It is also to develop partnerships with the most important companies in Brazil. It is also to foster education by offering full scholarships from early childhood education and to facilitate the entry of higher school students who cannot afford and wish to start a university degree. We also offer totally free English and computer science workshops. It is also to grant scholarships for the training of researchers and to be able to offer back to society all this knowledge. Our clinics also serve over 1 million people for free in health and family programs. We promote dental care, medical, psychological, and develop social programs that give full scholarships involving students in important social causes. It is also training and transforming people through education. Uninove, tradition and innovation in transformation through education.
Compartilhamos da certeza de que métodos adequados de resolução de disputas criam ambientes de negócio muito mais dinâmicos. Acreditamos em pontos de vista que, equilibrados, geram soluções mais justas e eficazes. Estamos entre as líderes no Brasil. Há 25 anos, trabalhamos para oferecer serviços ágeis e eficientes com custos de transação competitivos. Câmara de Conciliação, Mediação e Arbitragem Ciesp-Fiesp. Equilíbrio e celeridade.
Fala pessoal, tudo bem? Se você está vindo aqui pela primeira vez, meu nome é Franco Mazieiro.
Oi, Franco, obrigado pela pergunta. Olha, o especialista em direito aqui é você, não eu.
E esse é o canal Mais Direito. Não perca todo dia aqui no canal. Às 13 horas, programa Sexta com Direito. A gente vai conversar, a gente vai dar sequência para mais um O que é? Arras, TAC. Divórcio, desconsideração da personalidade jurídica, Lei Geral de Proteção de Dados, da inteligência artificial, startup, blockchain, guarda, recuperação judicial, técnicas de negociação. Você está acompanhando aí essa sequência de sugestões de temas de TCC, de monografia. Ontem nós conversamos sobre direito de família, direito e tecnologia. E hoje nós vamos conversar sobre direito penal, direito tributário, direito trabalhista, direito empresarial, direito constitucional. Eu queria uma aula com o nosso professor João Bosco do que é direito de concorrência, teoria do jogo e a arbitragem, direito societário, direito previdenciário, as cotas, a indivisibilidade das cotas, hacker, reorganização, arbitration, que é a teoria da imprevisão. Qual que é a diferença entre taxa e imposto, entre DPO e encarregado, entre conciliação e mediação. Vamos dar sequência aqui à correção de mais uma questão. Esse projeto que eu estou me referindo é o projeto Carreiras Jurídicas, que é a de delegado da Polícia Civil. Cartório de protestos do Procurador de Estado, profissão de perito. Muito obrigado a todos vocês aí de casa, sejam bem-vindos ao canal Mais Direito. Já fica o convite para se inscrever no canal para você poder acompanhar todos os próximos vídeos. Um abraço e até o próximo vídeo.